हाँ हाँ, मेरा कनेक्शन लग गया।
Court officer. Court officer. Hello, court officer. Hello, court officer. Hello, court officer.
ಹೇಳಿ ಸರ್.
ವಿಡಿಯೋ ಬರ್ತಾ ಇದೆ.
ವಿಡಿಯೋ ಆನ್ ಮಾಡಿಲ್ಲ ಸರ್ ಇನ್ನ.
Okay.
2 ನಿಮಿಷದಲ್ಲಿ ಆನ್ ಮಾಡಿ.
Okay.
ತಗೊಳ್ಳಿ ಶ್ರೀಧರ್ ಬಲ್ಲಿ ಬಲ್ಲಿ ಓಪನ್ ಮಾಡೋದೇ ದೊಡ್ಡ ಸಾಹಸ ಆಯ್ತಲ್ರಿ ನಮ್ಗೆ ಇವಾಗ. ಒಂದ್ ಬಂದು ಚೀಫ್ ಜಸ್ಟಿಸ್ ಅಂತ ಇರುತ್ತೆ, ಎಲ್ಲಿ ತಗೊಂಡ್ ಬನ್ನಿ.
ಫಸ್ಟ್ one ತಾನೆ.
ಟೋಟಲ್ 2 ಅಂತಿದೆಯಲ್ಲಪ್ಪ ಇದು.
ಎಲ್ಲಿ ಇದೆ ಟೋಟಲ್?
ಎಲ್ಲಿದೆ
CH2
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಇಲ್ಲ, ಚೀಫ್ ಜಸ್ಟಿಸ್ ಅಂದ್ರೆ ಫಸ್ಟ್ ಬರ್ಬೇಕಾಯ್ತು. CH2 ಅಲ್ಲ, CH1 ಅಂತ ಆಗ್ಬೇಕಲ್ಲ. ಏನ್ ಮಾಡಿದ್ವಿ ಇವಾಗ? ಪಾಸ್ ಲಿಸ್ಟ್ 1 CH ಅವ್ರು ಸಿಟ್ಟಿಂಗ್ ಇದ್ದಾರೋ ಇಲ್ವೋ?
ಸರ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಸರ್ದು ಸೀಟಿಂಗ್ ಇಲ್ಲ ಸರ್ ಇವತ್ತು.
ಇಲ್ಲ, ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರ ಇಲ್ಲಿ ವಾಯ್ಸ್. ಓ ಅದಕ್ಕೆ. ಓ ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಸರ್ ಇವರೇ ಇನ್ಚಾರ್ಜ್ ಇರ್ತಾರ ಸರ್? ಅಲೋಕ್ ಆರ್ದೆ ಅವ್ರ ಇನ್ಚಾರ್ಜ್ ಇರ್ತಾರ ಇವತ್ತು?
ಹೌದು ಸರ್.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Right. You are going somewhere. Not in the court. Huh? No, you are going somewhere. You are going somewhere. No, Mr. That case will be adjourned. There is no problem at all. See, what we fail to understand is that first thing we should do in the morning is to adjourn a case. I mean, what can be the urgency? What can be the urgency? Seeking an adjournment. This person wants to get his case listed. Should we not start a day with something constructive, Mr.? No. You are here, right? Or you are also going somewhere? No. So you are also going somewhere, right? You tell him, Mr. Note down his number 46. You go whatever, wherever you want to go. Please leave the courtroom. Yeah. What is the urgency? He is marrying. Married. Okay. No, again marrying. What I mean, urgency? What could be the urgency? That would. When do you want it? Day after tomorrow? Tomorrow? What is it? All day after. Fine.
My lords.
Huh?
My lords.
Huh? Yes, madam. Speak into the mic, please.
Oh, yes. My lord, serial number
Speak into
62,
the
my
mic.
lord.
MFA, what matter? FC. Family court. Okay. Fine. You are for the husband, right? In a hurry to get married. All right. When do you want? So what do you want? When do you want? The day after. Fine. You all this first appeal, etc. Yes. So this comes before this bench only. Section 9 arbitration. I don't think. No. That's why. Yes. This matrimonial disputes come before us, right? MFA comes. So when do you want, Mr. Tell us again. Thursday. Thursday.
May please, my lord.
1 minute. Yes. Yes. Tomorrow is a holiday. Will you come? Day after.
My lords.
What Thursday? Yes.
May please be.
1 minute. Mr. Amritesh wants to say something. Yes. Yes, please. What is it? Ray, we thought that you want us to take it today itself. There's no, it will be adjourned. Don't worry. Fine. You are well. All right. You are fine. No. Yes, Mr. Amritesh. It will be adjourned. Don't worry. We don't take it until there is some urgency and somebody mentions. It will be adjourned. Don't worry. Second list, you need not wait if anybody is waiting. Yes, fine. Call. Yes.
My lords.
Go.
My
Your
lords.
lordship, second list, your lordships will be taken up, or a date will be given, your lordships?
Date will be given next week, madam.
Your lordships may
Unless any matters are so urgent that it can't wait till tomorrow or day after, whatever.
Your lordships
It's all
may,
being adjourned to next week, second list.
your
My
lordships,
lords, cause
date
list
may be
number
given, your
1,
lordships.
serial number 62, my lords.
Huh?
Cause list number 1, serial number 62. If I may play
It
for
will
a
reach,
short.
madam. No, it will reach, madam. Please
All
have
right,
some patience. It will reach. That's
Definitely.
100% guarantee.
Yes, my lords.
Guarantee to you that it will reach. Have some patience. Yes.
Lordships, list number 2, serial number 8, may I request for a specific date, your lordships?
What? You give date, Mister. This, madam, list to whatever you want to mention, tell it to court officer, right? Don't this thing restrain us from proceeding with our court work. This is nothing. List whatever date you want, you tell court officer, he will give the date. Yes,
If
we have told you all
Yeah.
cases will go next week.
With your lordships kindly, my lords, writ petition 513 of 2022, it is disposed by your lordship and Justice MGS Kamal, my lords.
No, no, we
Actually, I
can-
sought for extension of interim order. I moved before registrar judicial, my lords. He told it will be only after constitution it can be possible, otherwise it's not
Oh.
possible. Therefore, I request my lords to have it.
And we want to know from you how the bench will be constituted. Who will constitute the bench?
No,
If
of
you
course,
can tell us.
No, Chief
No.
Justice,
No.
today
Then
your lordship is in
we
charge
can't-
of Chief Justice.
No,
That's why I
no,
moved before.
no. No in charge. He's very much there. They can get, if it is so urgent, he can, the registrar judicial can obtain his signatures on by fax. You have to convince that it is so urgent that
Because
your
today's
client
stay is
dying or
expiring, he's
something.
telling.
What?
He told us to move before portal number 1. That's why I moved before.
No, we can't do this, Mr.
Because
Honorable
of
the Chief
urgency,
Justice
extreme
would be
urgency is
available.
there, my lords. If it is
No,
not
this-
there, nearly 4.5 crores.
No, there is
money
nothing. we can't.
My lord,
All right, thank you.
My lord.
Yes.
Made, please,
list
your
number
lordship.
1,
Ah.
list number 1, serial number 17, I am for
Put down.
respondents. I have not
Please
received-
wait, it will, Mr. We can assure you that it will reach, provided you permit us to begin.
Yes,
I want to assure you 100% that item number, all cases in item, list 1 will reach. It's not that we will, the day will end at 4:45 at item number 15 and you will be allowed to wait whole day. It's not, doesn't happen in this court. You have seen our performance. I mean,
Achha.
please, I will request you with folded hands, please allow the court to proceed. He is still waiting to call serial number 1. We don't know
My
what
lord,
is
may I
it.
seek an
Currently it will be
adjournment?
called. Nothing. You give your name to court officer. Yes. Memo for acceptance. Yes. Memo for service of notice by paper publication on the respondent is accepted.
I am appearing for respondent in this case, my lords.
How much time?
I served the copy, my lords.
Time matter.
I have served the
Merit
copy.
counsel correspondent submits that the copy of IA 1 of 2018 has been served on learned counsel for the petitioner. What do
Yes.
you want, madam? In view of opposite office objection is ignored. What do you want?
Now,
Let the petition be listed for orders. Password means what? It is listed for default. What password? He has complied. You have got the copy, right? So, office objections ignored. Opposite strength office objections ignored. List in the next week. Yes.
Number 3, the Loknath government advocate.
Non taking of steps.
I'm up for appellant, my lord. Pray for 2 weeks time, my lord.
Oh, yes, Mr. Sandeep Puligal, learned counsel for the applicant. No, you are for respondent, right? In pleading applicant. He is petitioner.
I'm for appellant, my lord. 2 weeks
What's
time
his
will be
name?
granted, my lord. We will
What's
take
your name?
Your name?
Bayresh V.
How much time? 2 weeks
2
time
weeks,
to
my lord.
enable him to comply with office objections. Fine. Yes.
Grateful, my lord.
Government advocate.
Whatever. All right. Narrate counsel for. Fine. All right. What's your name? Mister, nothing to argue. We have accepted it. Learned counsel for the appellant prays for and is granted how much time? 2 weeks time to enable him to comply with office objections. after hearing learned counsel for the appellant, office objection number 2 and 3 is ignored. Yes. We don't know. You have not argued on admission. You have prayed for 2 weeks time to comply with office objection. We will hear you. Next. We have passed an order. You didn't hear? Yes.
Number 5, Shri Pramod.
Serial number 5, I am for petitioner membership. Weeks time may be granted for to take substitute service.
Either is unable. We are not audible for what. Yes.
For petitioner, weeks time may be granted to take substitute service.
Number 6, Shri Mahesh, yes.
Ready? All right. We'll hear it today. Nothing. There's nothing to. We'll hear it today.
Number 7, Shri Nagendra Nayakar.
My lords, appearing for the appellants,
How much time?
2 weeks time may be granted, my lord.
Next.
Number 8, Shri Kartik Kumar
Much
K.
Appearing for the petitioner, my lord, I seek for a week's time to comply with the office.
Within 1 week, issue notice, Mr. Notice on behalf of so and so is accepted by learned SP.
Number 9, Shri
Yes, what? Mr. All right. Fine. Krishnamurthy, senior counsel for the applicant, after hearing learned counsel, senior counsel for the petitioner, office objects is ignored. Yes, Mr. Right, you are appearing for which respondent? Mr. Srinidhi, right?
Yes.
For learned counsel for 4 and 5. We'll take it up day after if you want. Let the appeal petition be listed for orders on admission as well as consideration for prayer for assembly. Day after tomorrow is what? 2nd March 20.
AGA for 1 to 3.
AGA. All right. So you are also appearing, right? We have not issued notice as yet, but you appear advance notice. All right. AGA for advance notice on advance notice, right? For respond number 1. Yes. It will go, madam. It's been listed for admission day after tomorrow. It will go, definitely. Don't worry. Yes.
Number 10, Shri Suraj Naik, government advocate.
Yes. What is it? You will comply. What is it? All right. Mr. M.R. Naik, learned senior counsel with so and so counsel for the petitioner. Mr. Whatever is who is assisting you? Suraj Naik. What's your name, sister? Undertakes to comply with office objections during the course of the day, heard on question of admission, issue notice, emergent notice to respondents. Notice on behalf of our respondent number 1 and 2 is accepted by Mr. Learned Edition Comment Advocate. Issue notice to respondent number 3. In addition, so and so is in liberty to serve Mr. N.K. Ramesh, learned counsel, who ordinarily appears for respondent number 3. Office is directed to reflect his name as counsel for respondent number 3. Thursday. All right, Thursday, 3rd March. List on 3rd March 2020.
Hearing on IAS, number 11, Shri C. Shri Party.
Yes. Right. This is what restoration. Right? Is to allow restore. Next.
Number 12, Shri Naveen Jain, government advocate.
I appear for the appellant, your lordship. I filed this application.
Here, copies, etc. How much time, Mr.
During the course of the day, I will pay the process.
They have been served, right? They have been served.
They have been served, your lordship.
Right, restored, recalled. IA is allowed.
Please.
Yes.
Obliged.
Number 13, Government advocate.
What is it? Await service of notice on respondent number 6. This thereafter. So 6 has not been served. That's what. That's why await service of notice on respondent number 6. Let the appeal be listed as soon as the respondent number 6 is served. You know that he will be served by next week. All right, list next week.
Appearing for the petitioner, my lord.
Must have consulted them, Mr. He will be served on Tuesday, so it will be listed on Wednesday. Very auspicious for you.
Appearing for the petitioner, my lord. Praying for short accommodation. 2 weeks time might be granted, my lord.
Oh. What's it? Her name pays for adjournment. Yes, but she is praying for adjournment. Any objection? Mark her presence. Correspondent 3 and 7. Learned counsel for the petitioner prays for adjournment. On what ground?
Senior is not available, my lord.
Oh, senior is not available. This after 2 weeks.
Madam, your name?
Devi Sukanya.
Madam, you have not served copy of the amended petition and annexures despite direction. What should we do?
We have served, my lord.
Served.
Acknowledgement is there. I will submit the acknowledgement, my lord.
No, do you want to contest this issue or can you supply an extra set? We don't want to give a finding on this.
We will submit.
We have better things to do. I think
we will submit, my lord. I will submit it.
Please supply an extra.
I undertake to submit it, my lord.
Petition along with annexures to learned additional government advocate within 3 days and praise for adjournment on the ground. Arguing counsel not available. List after 2 weeks.
Much obliged.
Oh, what posting? So posting is infructuous, right? So when should we hear? What is it?
Private entity given the powers to draw the lines. Whether a private entity can exercise such powers in a manner that the rights of the petitioner in respect of his properties are trampled. The panel has been drawn in respect of the nature of the act which is undertaken under the Telegraph Act and akin to section 17 caption of the Land Act of 1884.
Right.
The difficulty for me is that they are seeking to draw the lines in respect of the properties without payment of compensation. There are no difficulty. I made a statement that if they are paying the compensation, utilizing the property, that's a different matter. But they can straight away come and enter into anybody's property, put up the lines.
What had happened? The notices have not been issued. Issued. What is it, Mr.? Have you filed this thing? Response? Yes, madam. Notice. So who? So what do you think? So when was the notice issued, Mr. Ravi Shankar?
Fixed was 1/4. Next date fixed was 1/4.
1/4. This has how this has come up, Mr.
Because of that IA.
But this one. This IA for posting. The date, the matter had come up on 8th of February 2022 and it was directed to be posted on 1st of April 2022. So how this has come up, we don't know. This perhaps memo. That's why they are entitled to this, right? Mark their presence, Mr. Ravi. The notice has not been issued. We don't think formal. Issue. Mr. A. Ravi Shankar, learned senior counsel for the petitioner with Mr. So and so. Heard on the question of admission, issues notice to condits, notice on Mr. D.R. Ravi Shankar, D.R. Ravi Shankar. Notice on behalf of respondent number 1 and 2 is accepted by Mr.
Order.
Yes.
21/12.
21.
21/12.
Notices have been issued.
Under 6 for 1 and
All right, all notices have been issued. I'm sorry, please. Notices have been issued on 21st. All right, so learned counsel for respondents so and learned additional government advocate pray for our granted how much time matter? 3 weeks time to enable them to file objections. List no orders. Then above that you receive. So since the matter is listed for orders on already listed today, no orders are required to be passed on IA 1 of 2022. List on. We will give you a date. 3 weeks. Based on 23rd March. Yes, 23rd March 20.
16, Sri Abhishek Malipati, Sri Mansi Kumar, Sri NKT,
Yes.
Hanuman.
Oh, this we'll take it up. Whatever. Yes, we'll take it up. Yes.
For December 17.
My lord, I am for.
Yes, Mr. Joshi. See,
I am for
you are,
respondent.
thank you for your patience for 15 minutes. Yes.
We are at the hands of my lordship.
No, please.
I am appearing for respondents. I have not received the copy of the IA 1 of 2022.
Yes, madam. Please supply. Who appears? So please supply copy. Write her name, learned counsel for the applicant. Mr. Let a copy of IA whatever 1 of 22 be supplied to learned counsel Mr. Guru Raj Joshi, learned counsel for respondents 1 to 9 and 11 to 19 within within 2 days. Yes, Mr. Joshi, how much time do you want?
I require a week's time to file objection for that IA.
Week time to enable him to file objections to IA 1 of 2022. List thereafter.
Much.
Yes.
Number 18, Sri Swami MN, Sri K.R.
Lord, I appear for the appellant, Lord.
Yes.
I appear for the appellant, Lord.
Yes.
This is a matter, Lord, wherein, in fact, Lord, the appellant, in fact, as an education institution, which appointed the respondent here in my lord on a temporary basis in 2007. Am I audible, my lord?
This petition is already admitted, Mr. Swami, on 31/8/2021. It has to be posted for hearing now.
All right. Let it be called for hearing.
No, and the other side is praying for adjournment. You are appearing for which this thing, which respondent?
Only respond.
Only respondent. The outgoing counsel is unwell.
All right.
It has already been admitted for hearing on 31/8/2021. List the same for hearing.
Much of this.
19, Sri Sarvana S, government advocate, Sri P. Seshik Vidar,
Yes. You will file a synopsis. File. Who appears for respondent? Opponents will pass it over. Let's see.
December 20, Sri Sarvana S, Sri K. Puttagowda.
Yes.
Lord, I appear for the respondent.
Yes, please.
My lord, here, my lord, the appellant converted certain agricultural land
for
non-agriculture purpose.
Petition for amendment is there. What is his response? No, wait, Mr. Ravi Shankar, there is some amendment you have filed. What is it? Yeah, what do you say, Mr. Puttagowda? Yes. What do you say with regard to amendment?
Amendment may be allowed, my lord. There is no.
All right, heard on IA, mark the presence, Mr. Ravi Shankar, D.R. Ravi Shankar, and senior counsel with so and Mr. K. N. Puttagowda and counsel for 1 and 2, heard on IA 3 of 29, taking into account the nature of proposed amendment and for the reasons stated therein, same is allowed. let amended petition, amended memo of appeal be filed within 1 week. List thereafter.
Number 21, Sri Govind Advocate, Sri D. Vatan, Government Advocate.
For the respondent number 3, my lords.
Yes.
My lords, the underlying dispute is a family dispute, my lords, which has been settled before the trial court in Mysore. The compromise has been filed. It has been taken on record. The formal decree has to be passed.
He is praying for 2 weeks' time. Counsel for appellant.
May I request this, my lord? A 4 weeks' time may kindly be granted. A decree has to be drawn with the trial court.
Okay.
And we do
The
not.
counsel for the parties jointly submit that the dispute between the parties has been amicably settled. However, a decree has to be drawn by the trial court. Full stop. They therefore jointly pray for adjournment list after 4 weeks.
Oblige, my lord.
My lord, serial number 22. There is a bereavement in the family today. I just require this matter, my lord, to be taken day after tomorrow, my lord.
What happened?
No, there is a bereavement today. Just, my lord.
Bereavement in
day after tomorrow, my lord. Go ahead.
all right. Yes. Next week, Mr. What's his name? Mr. K.V. Narasimha. No, Mr. Nitesh Laurent, counsel for the appellant. Mr. You are appearing for?
Respondent 3.
Mr. S. Babu, Laurent, counsel for respondent number 3. Laurent, counsel for the appellant submits who suffered a bereavement in the family.
appear for the
Case for adjournment.
respondent
This in the next week. Next week. Sorry.
Say, my lord, please.
Next week.
24, Government Advocate, Sri Arjun Rao.
24, my lord, appear for the respondents. May I please request an adjournment, my lord. Senior counsel who have engaged is not available today.
Yes. Laurent, counsel for Mr. Arjun Rao, right?
Yes, my lord.
Laurent, counsel submits that the arguing counsel, namely, who is the counsel?
My lord, Mr. V. Srinivas Raghavan, senior advocate.
If Mr. Raghavan is not available, he therefore prays for adjournment list after 2 weeks.
I'm grateful.
Number 25, Sri Balasubramanian here.
Yes.
I represent the appellant's advocate. My lord, I may be permitted to represent the appellant's advocate. Lord,
what is it?
Yes, Lord, the dispute regarding mutation of. Yes, my lord, there is a delay, my lord.
Yes.
He was not well, my lord.
Who is not well?
Lord, on the ground of health, my lord, delay condonation has been sought. Petitioner was not keeping well.
Yeah, please considering who appears for Mr. Respond number 4.
Sri Prakasham Patil.
He will file an application for recall. Delay has been controlled. Pass over. Let him come, pass over.
Please.
Second, only if he doesn't appear.
Please.
Number 26, Sri A. Madhusudan Rao, Government Advocate.
This is all concluded, right? Who appears? Madhusudan. Where is Madhusudan? This all AGP Act virus has happened.
Yes.
It has to go before division bench, a single bench now for remaining reliefs, right? What is it, Mr. Give it. Virus, no? Yeah. Declaring Karnataka land grabbing use, which is Mr. Karnataka Land and Justice Arvind Kumar judgment. Where is that? You had this copy, no? Party presence in this rate petition, the petitioner inter alia has assailed the validity of the Karnataka land grabbing prohibition Act as ultra vires the Constitution of India. The validity of the affected act has already been upheld by division bench of this court in Where is it?
Yes.
Division bench of the court wide order dated 19th January 2021, passed in WP number 144741 bar 2017. Full stop. Therefore, for the reasons assigned lying below, for the reasons assigned in the aforesaid judgment, the relief in so far as it pertains to claimed in clause A.
Yes.
A does not survive for consideration as the validity of the act has already been upheld by a division bench of this court. Let the writ petition be listed before the it will go before single bench, right?
Sir, we have said all this. See, there is a appeal remedy. Is there?
Oh.
He is going for appeal remedy.
Mr. Rao. So what? I mean, everything is over now. You should go to Supreme Court. Huh? No. He has written. And what about this 12.3.19? You have the remedy of an appeal. Huh? Huh? What this? Huh? Wait.
No, it's not before the special court.
Huh? Why? Why? Why it has to go to civil? You are challenging the order dated 12/3/2019, right? So that will be adjudicated. Huh? Fine. Why? Special court was not constituted on the date of transfer. No, please.
Was filed by the ladies, that is the petition before the doctor, in respect of the property. It was granted to the petition. Who was earlier decreased? The matter was taken in appeal. Before the problem, along with two other connected appeals. The appeal came to be remanded to the trial court. Because the suit came to be decreed in our favor. But then the appeal was filed by the other side, by the government. Appeal was allowed, and the matter was limited back to the trial court.
No, all that is fine. So your suit was pending on the date of commencement of this act, right?
That's what I'm submitting. Similar situation.
Not pending. Now, what is your submission?
My submission is that once you will not take MIB, you are not to pass on judgment of
No, what is it? I mean, what is your case that suit was not pending on the date, therefore could not have been transferred? Why?
Similar cases, this one who could have had that your suit will not be transferred. And pass on the judgment.
Why it can't be transferred? Please tell us. You have read the judgment. We are asking you simply why it can't be done.
They read the relevant portion. Where the civil suit has been filed.
We don't know. He is unable to tell us. You find out. No. Let the. You should tell us, Mr. Rao, why it is. Simple question is why it can't be transferred. That's what we are asking.
The suit, the declaration of right to suits are right before the trial civil courts.
Yes.
In such cases, the question as to whether the land is a granted land or not, whether there is an encroachment or not, these are the issues cannot be decided by the
Land grabbing court. That's it. Learn it. Counsel for the. That's what we are wanting to know from you. We without reading, we wanted to know from you. Learn it. Counsel for the validity is upheld, does not survive. Learn it. Counsel for the petitioner submits that the order dated 12/3/2019 passed by the land grabbing court. No, this is you have said first additional order dated 12/3/2019 passed by the trial court in OS number 263/2003 deserves to be quashed as the issues pertaining to title and encroachment cannot be adjudicated by the special court under the provisions of Karnataka Land Grabbing Act in support of aforesaid submission, Reliance has been placed on decision of division bench of this court in ILR Karnataka 385, and as well as another division bench decision of this court in WP number 5090. In view of aforesaid submission, learned additional government advocate prays for short adjournment in order to enable her to examine the aforesaid aspect list next week. Next week. We decided now. It's the no, it's all right. No, all right.
Number 27, Sri Gurudutta case, government advocate.
IA 1 of 21 is dismissed as not pressed. What is it, Mr.? All right, so if you have got same marks, both of you, and she has been given precedent because she is elder in age, what's wrong with it? Reference. Where is that? 23/1/2014. Where is it? It's the paraphrase. Paraphrase. Selection. If Anganwadi workers. If Anganwadi helpers are available in the village, question of inviting application from other candidates for the post of Anganwadi worker to such Anganwadi center, then what? Huh? No, what we could make out, madam, is that it is incomplete sentence.
Next one is.
Invite application. He participated in the process, did not assert the time of fiction. So what?
2 years, 2 months.
Yes. No. When was this advertisement issued inviting applications? So what did you do at that point of time? Then, so the advertisement could have been issued, right? Could have been issued. What is wrong? There is no, not seniority. So nobody, this is a selection to the post of Anganwadi worker, right? Nobody's, you continue as a helper. Oh, what basis you are claiming selection? Please tell us. Not there, no. So on the date of advertisement, you had not completed 3 years of service. Not liberally. You should have come at that point of time to this court to enable us to read liberally, whatever. Now at this point of time, we are not inclined to read it liberally because you have not come at an appropriate time. Why did you participate in the process of selection and took chance? Supposing if you would have been selected, then you would not have come, right? This all happens. What to do? Ask her to forget about nothing. Yes, this. So this item number 27. 27. Of the presence heard, this intra-court appeal has been filed against the order dated 24th November 2020 passed by Learned Single Judge in WP number. Learned Single Judge by which read petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellant and fifth respondents were the candidate that giving rise to filing of this appeal briefly stated are that a notification dated 23/1/2014 was issued for recruitment to the post of Anganwadi worker. The appellant as well as respondent number 5 submitted their applications for appointment to the post of Anganwadi worker. The appellant as well as respondent number 5 secured equal marks. Full stop. Equal marks. Full stop. Thereupon the selecting authority selected the respondent number 5 on the ground that she is elder in age to the appellant. Full stop. Elder in age to the appellant. The appellant thereupon paragraph. The appellant thereafter questioned the selection and appointment of respondent number 5 on the post of Anganwadi worker by way of a writ petition, which has been dismissed by Learned Single Judge, wide order dated 24th November 2020. 2020 inter alia on the ground that the government order does not require any preference to be given to Anganwadi assistant. Paragraph. Learned counsel in the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant submitted that the appellant was working as an Anganwadi assistant and therefore was entitled to preference in the matter of appointment. It is further submitted that the eligibility, that the condition number 5 in the government order dated 15/6/2012 should be construed liberally, and the requirement of service of 3 years should be read as 2 years and 2 months. Right. So on the other hand, learned government advocate, additional government advocate submitted that since the appellant had not completed 3 years of service as Anganwadi assistant, therefore the application was invited for recruitment to the post of Anganwadi worker. It is further submitted that there is no merit in this appeal and the same deserves and no interference is called for with the order passed by the Learned Single Judge. We have considered the submission made by Learned Counsel for the parties and have perused the record. The government order dated clause 5 of government order dated 15/6/2012 provides for a preference being given to an Anganwadi assistant who has completed 3 years of service. Full stop. Admittedly, on the date of issuance of the advertisement dated 23/1/2014, the appellant had not completed 3 years of service as Anganwadi assistant, and therefore she could not have claimed any preferential treatment in the matter of appointment to the post of Anganwadi worker. Full stop. It is further submitted. It is pertinent to note that the appellant had participated in the process of selection, and after not having been selected, had questioned the same. Full stop. In other words, the appellant did not agitate her entitlement to claim preference in the matter of appointment, to which she was otherwise not entitled at the earliest point of time. Full stop. For the aforementioned reasons, we do not find any merit in the appeal. The same fails and is
Number 28.
Why for next week? Place for place for adjournment list next week. 4 to 7. He appears for 4. What's your name? What's your name? Mr. Shashank Learned Council undertakes to file wakalat on behalf of respondents 4 to 7.
Already somebody has filed.
Somebody has filed.
And Mr. Yugandhar has already filed wakalat. R4 to 7. Yes.
NOC wakalat.
Number 29. Mariappa.
Ah. Huh? In council is not there. Arguing council. What? What time? Well, do you know why your petition has been dismissed? You know why this petition has been dismissed? You know? Don't know. Why do you want an adjournment? What? No. You want to argue, right? Please go ahead. Why? Not there means where? He is where we want to. Not there means where? What is?
Council is not. Council is not in town, is it?
Not in town.
Not in town.
But he can appear through video conferencing now. You need not be in Bangalore. Lawyers appear before us from all over the country, like Chennai, Delhi, Bombay. They need not remain present. Probably this ground has gone now due to COVID. This online thing, it has disappeared that he is not in Bangalore. Huh? Find out.
Next week.
Achha, praise for adjournment list next week. Please argue next week, and please find it out. What is the case about? Don't be under an impression that you have a fundamental right to seek adjournment. We have been repeatedly telling this. What happens if we decline? This is all live streaming. If your client sees what happens, please understand. Behave sensibly and responsibly in the courtroom. This is all being live streamed. Yes.
Number 30. The requested case. Sumana Naganan.
Yes. What is it? Yes, please.
This is arising out of the registration of birth and death act number 1959. If you may not the facts are, the appellant is the wife of the original petitioner, which is respondent number 4. The appellant made an application for change of the birth certificate. The same was allowed by
change of name in birth certificate.
Change of name in the birth certificate. The reason for the name change was for historical reasons. It was carried out in 2016. And thereafter, there's some marital discord between the husband and the wife.
Right.
So the husband filed a petition for the court saying that.
But what is the order?
The order is, it is stated that the procedure as contemplated under Rule 11 of
No, what operative portion of the order? Please read para 9 at page 40. This, what we want, why are we asking you to read it? Because prima facie it appears to be an innocuous order. You will be given an opportunity. Respondent number 4 will be given an opportunity. Authority will take a decision and hold an inquiry in terms of section 15, pass an order. Until then, A and B have been kept in abeyance. So how are you agree? That's what I mean. Instead of by now the inquiry must have been completed. I mean, if they had acted diligently.
Another single judge, para 7 has stated that the first respondent ought to insist for a joint affidavit by laws. This requirement of joint affidavit is not there in the anywhere. And since it is already pointed out by the learned single judge.
No, where is it? Insist for joint.
Page 38.
Page 38.
38.
Where is it?
The first respondent was required to examine as to whether there was an erroneous entry at the first instance. If there is no erroneous entry in the first instance, then it was incumbent on the part of first respondent to insist for a joint affidavit. So today, participate in any inquiry also, my lord.
We will keep it open for you to raise a contention that it's not necessary to file a joint affidavit. Fine.
I have made a specific submission single judge saying that there was an FAQ which has not been referred to in the learned single judge's order, and the FAQ does not have any force of law in it. Apart from that, section 30.
No. Please read para 9 and tell us how are you aggrieved by this order. When we asked you to read, you took us to para 7. Then we said para 7. We will say that there is no need to file. You can raise this contention. Then you are saying that FAQ. What is this?
Interpretation of section 15 and the rule.
By now, Mr. Are you interested in making your client's life complicated or advise her to live in peace? The inquiry is being held by respondent number 1. You have been given an opportunity to participate in that inquiry. The authority will pass an order afresh after hearing both of you. It's that. Please tell us how are you aggrieved by this order? Please tell us.
Because this would be an empty formality.
We don't know. How can you say so?
Already made up the mind saying that the joint affidavit has to be filed.
We will clarify that.
No petitioner, he's not going to anyways, he's not going to give a joint affidavit. So automatically the birth certificates, new birth certificates will get set aside. So this is
Well, see, more than once today in the proceeding, we have been given to understand. Me and my brother, both of us, carry a prima facie impression from your submissions, and including others, that probably some of you have consulted the astrologers today. That what this will happen, that will happen. He will pass an order. Single judge. What happened in the past? Single judge made up the mind. Authority will pass an order like that. Really, I mean, have you considered? We don't know. How can? Oh, so see, that's really, I mean, this has a connection with an astrologer. My lord rightly points out, according to astrological, the new names are good for their future. So you must have consulted an astrologer. No, you have consulted, right? That's how you are telling that authority will pass an order. This is. No, please, please tell us, how are you aggrieved by the order?
My lord, sir, in my submission, my lord, section 15, it does not, section 15 is interpreted by the Honorable Gujarat High Court, where the words error in substance and form is being interpreted.
So where is, then file a review. All this you have argued Gujarat High Court. And, so how has it been met with? No. Dealt with? No. Dealt with. Then if an argument is raised and not dealt with, what is the remedy of a party? What does Supreme Court say? A.R. Antuli. Please file it. According to us, it is totally an innocuous order. We will say that first respondent shall decide the matter without being influenced by any of the observations contained in the order. It will be open for you to say that there is no requirement in law to file a joint affidavit. That issue will be decided by respondent number 1, bearing in mind requirement of law, if any. That's all. Nothing, Mr. All right. Okay. Yes, this is good. Oh, we don't know.
Page 99, my lord, where I put the English version also.
No. What I mean, having agreed just now, you again started arguing. No. Either please proceed to argue. Perhaps we were being frank with you. We should not have disclosed our mind. We should have heard you, and then after you have left the courtroom, we would pass an order. We wanted to be fair. That's why we disclosed our mind with you. So then, having agreed, you said it's okay, right? What did you say? It's okay. Then again started arguing. Page 99. Everything is kept open, Mr. The authority you will have. The doors of this court are open. Again, you are welcome. If you are, I mean, we don't know whether you will come. You will stand on that side, and Mr. Sriranga will be here. We don't know, right? So we don't know who will fight. So what? There's nothing. It's an innocuous order. Yes, mark the presence. Mr. Rikap Chand, learned counsel for the appeal. Mr. You are appearing for Mr. Sriranga? 1 and 2.
Respondent 4.
4. Mr. S. Sriranga, learned senior counsel with learned counsel for respondent 4. Yes, you should have told us that you are appearing for hospital. All along we were saying that the authority will pass. You don't. All right, learned senior. Husband. All right. Oh, it's 4 shows. I'm sorry. Yes. 4. Respond number 4. Yes. Learned counsel for respond number 4. I thought this hospital. So all. Yes. This intra-court appeal has been filed against order dated 9th of August 2021, passed by the single judge, by which the writ petition preferred by respondent number 4 has been disposed of with the direction to the health officer, DPMP Bangalore, to afford a reasonable opportunity to the applicant as well as the respondent number 4, and the birth certificates which were impugned in the writ petition filed by respondent number 4 have been kept in abeyance till the health officer concludes the inquiry. It has further been directed that the same shall be subject to outcome of an inquiry which may be made by health officer in terms of section 15 of the Karnataka registration of births and deaths in 1969, read with rule 11 of the rules framed therein. Paragraph: after hearing learned counsel for the parties and in the facts of the case, it is clarified that the health officer shall, after that, it will be open for the applicant to raise a contention before the health officer that there is no requirement of filing a joint affidavit, and the health officer and the respondent number 1 shall advert to the requirement of filing a joint affidavit by with reference to the provisions of the law. Full stop. It is further directed that the health officer shall decide the issue pending before it after affording an opportunity of hearing to the appellant as well as respondent number 4 without being influenced by any of the observations contained in the order passed by the learned single judge. Right? Line below: to the opposite extent, the order dated 9th of August 2021 passed in the WP in the writ petition modified. Accordingly, appeal is disposed of. Yes. Before the needless to state, health officer of BPMP shall conclude the inquiry within 1 month from the date of receipt of copy of the order. The opposite extent, order is modified. Appeal is disposed. Yes, Mr. Karan. Why you are not in a position to execute the sale deed? Oh, yes, Mr. You have got the copy. What do you say? Huh. Oh, but you can consider, all right, not this thing, site number 661, but some other site in the locality. Huh? Given. Yes, yes. No, but the direction is 661.
Now the direction is 661 only has to be given. But they have already given alternate. He doesn't want alternate.
You don't want alternate site.
We want they are suggested. That was just actually they was allotted 13 to 40. Now they are giving 20 to 30. That is the 2 number.
13 to 40 is 661, right? So then how much they are giving you now?
Now they have proposed site number 219 alternative site. It is less 20 to 30 minus 10.
Yes. Yes.
We are going to give him the same equal measurement. These are his representation. But he comes to the court saying that in spite of knowing the fact that the land has been gone in a redo, he comes and puts for execution of the very same kind.
No, so please give him an alternate. He is agreeing. No. Why litigate? I mean, you should. So give him a site of this measuring 30, 40. He'll be happy in a nearby locality, whatever is adjacent, whatever. Which place this 661 is there, Mr. Site? Arkavati. So 8th block you will give him somewhere. 1200. 8th block.
8th block, if it is available for this, if his other side is agreeable to mother block.
Or in some other block also. Which other block? Same layout, yes. Right? Same layout. We are not saying you find out. Find out. That's what he's saying, that it shouldn't be disposed of like this. He will have to come. He doesn't want to come again, right? Yes. His client doesn't want to come. Fine. So find out. Yes. This intra-court appeal has been filed against order dated 27th November 2020, passed by the learned single judge, by which writ petition preferred by the respondent has been allowed, and the appellants herein have been directed to execute the registered sale deed in respect of site number 66, situated in block in 8th block of Arkavati layout, Bangalore, in favor of the respondent within 3 months. Paragraph. Rule 11A of the which rules? Bangalore Development Authority. Allotment of sites. Rules 1984 contemplate that an alternative site has to be allotted to the to an allottee in case the authority is unable to execute a sale deed in respect of the site which was originally allotted to him. Full stop. Learned counsel for the authority. Grace warrant is granted 2 weeks time to enable him to seek instructions and to make a statement before this court whether it is possible for the authority to make allotment of an alternative site to the respondent in Arkavati layout.
Same dimension.
Alternative site of same dimension, right? Same dimension means 13 to 40 in Arkavati layout. List after 2 weeks. He is interested. No, not. He said enough. No. You can always come back if he says, if he gets the contempt petition listed day after tomorrow, please mention. Huh? No, we are asking him to mention, not you. You have a potent weapon in your hand, so you need not. You will exercise. Huh? That's why. That's why we are not, do it, Mr. Advise them. Why should they? Yes.
Number 32, here you are Deshpande, government advocate.
Yes.
Here you are Deshpande.
Pasu.
Pasu. Number 33, the Ugrappa VS, the Vamsi Krishna, government advocate.
Yes.
Village Station.
Oh, yes.
Nagarajappa.
Oh, ready, Mr.
Matter. And we got visible information of a town panchayat member. He was elected in a general constituency on 31/8/2018. No elections were held for the post of president and vice president till 2020.
Yes.
In the president's election, so it was a unanimous election, as there was only one candidate for the post of president, two also for the post of vice president. As the applicant was not keeping well, she came there and she came to know that only one candidate for president and one candidate for vice president. Nominations were filed. So, thinking that it will be unanimous, as she was not keeping well, she was suffering from a fever. So, thinking that it may be COVID-19, she went back. So now, after a lapse of some time, after 2.5 months, a district president of a same political party, though the elected member was also a member of same political party, that is Janata Dal, yes. So they filed a complaint stating that she has disobeyed the whip issued by the political party. In fact, the whip issued by the political party, in fact, as per the provisions of law, whip has to be issued by the party. So here is a case where there is no authorization by a person who has issued the whip. We issued the B form and B and A form. So in fact, that was signed by Mr. H.D. Devarappa, who is the national president of Janata Dal. So here is the case where district president is Anjanappa without authority of law. In fact, as for the judgments rendered by the Honorable Supreme Court of India and other courts, there must be a resolution by the member or by the authorization by the political party who has issued the B form. Here is a case where there is no such authorization. So in the name of district president, he has filed. Yes, he has filed a complaint before the authority concerned. So that authority has to refer the complaint within 24 hours. Unfortunately, here is a case where that application, that complaint has been referred to the deputy commissioner after a lapse of few weeks. Thereafter, even deputy commissioner. So who is the authority who has to decide this matter? On 60 days, he has decided the matter after 154 days. So stating that even absence where there is no election, so it has to be considered as she has violated the bill. So in fact, my lord, there are judgment.
Yes.
Sir, counsel for the respondent. You are appearing for which respondent? You are reading the matter.
What other respondents? What about others? What who appears for 5 and?
A. Nagarajappa.
And what about 7 and 8, Mr. Counsel?
Sir.
7 and 8?
Yes, sir.
Unrepresented. Okay. And Mr. Nagarajappa. Not there. So shall we pass it over? The counsel for respondent number 7 and 8 is not there. Huh?
I'm seeking interim relief of stay of
We will take it today. Take it today. Don't let, in the second round, if it doesn't appear, we will deal with your case. Fine.
for the
Government advocate.
I appear for the appellant. In this case, I appear for the appellant.
Yes.
The appellant is the owner of the property.
Yes.
Respondent claimed that he was a grantee of the property in the year 1964. 1964. The court summoned the grant book.
Mr. Raghu, you speak into the mic. What happens that he gets an impression that we are seeking adjournment. So your voice is not audible to him. He feels like that court is seeking adjournment. So speak into the mic so that Mr. Raghupati,
yes.
The counsel for petitioner, respondent is seeking adjournment to place the rejoinder on record, which was filed by him before the right.
That the interim order
in the next week.
That the interim order continue.
That's what he told us. There is an order maintaining status quo. Fine. Mr. T. Raghupati, learned counsel, T. N. Raghupati, learned counsel for the appellant, a learned senior counsel for one. Respond number one, learned senior counsel for respond number one, place for short adjournment to enable him to place on record certain document, place on record the rejoinder filed by respond number one before the learned single judge. Interim order granted on earlier occasion shall continue. List next week. Next week, Mr. Raghupati.
Week after next, if it is possible.
Week after next. Why not? List in week commencing, whatever, week after. Please. 7th March. No, 14th March. 14th March 2020.
35, M. Shivprakash, P. N. Rajeshwara.
Yes. Yes.
Where a trade license has been issued to this appellant, that has been stayed. The fact in total is not properly stated. Now the basis for entire thing is
What happened on 1910? Not heard. It was directed to be listed on 1910. Not heard. Okay.
Page number is 261. These persons are claiming 291. The claiming certain rights under one person. And that claim which they are claiming, and that person already a competent authority has given a verdict that these are the fake documents and these are the manipulated documents and the bogus documents. 291. Page number 291. The point in time is whether how we got this title and what is the rights. Now, in the page number 297 is the particular page number I am taking.
It would have been better if you would have prepared a synopsis, Mr. Since it is all involved facts. You should have prepared. These are the correct facts. This is what the court has got it wrong. So it would have been better and easier, no?
It's a which requires a detailed reading also. That's why my lord instructs me to clear the synopsis.
Please. It will be easier and faster. That's what. Since you are. Please, when do you want? Tell us whenever you are able to get the synopsis. We'll fix it on that. 4th Friday. Yes, Mr. M. Shiv Prakash, learned counsel for the appellate. Mr. Rajeshwara, P. N. learned counsel for respondent, learned counsel for appellate undertakes to prepare a synopsis and produce refer to court for facility of reference list on 4th March 2020. Whatever objections you want to file, it's filed by next day. Fine.
Tanika and Ravishankar yet?
Yes. Yes, please.
Depending upon life certain benefits are extended to the landowner. And my lord, the legal court is not paying 175.
In page 175, right? Yes.
Directed to make representation. And my lord, my case is not 175, paragraph 2. Committee was 175.
175?
Yes, paragraph 2.
Paragraph 2?
Yes. The committee was constituted in fact.
176. 176.
Inner page 745. Inner page
7?
745.
So it begins like the commissioner, BDA and others and examine all such representation. Then where are you?
This is what the committee was constituted by, high level committee was constituted by the court.
Fine.
And all the landlords directors. My case is slightly different too, right? Slightly different. My case was not at all considered because individually they are dealt with the matter. But in my case, representation was already rejected and I have a litigation against that earlier. And what division being set us order. During that time, a lot of modified scheme was introduced and the scheme was challenged. My prayer was annexes page 199. Prayer 199.
Reasserting.
Yes. Issue, yes, reasserting. This reasserting is not in the light of the government has granted approval for the modified scheme. The government has granted approval to the modified scheme. With the condition to BDA, stating that it once again reascertain whether or not the land is excluded from acquisition or not. But this is a prayer. My prayer was not at all considered, though my matter was listed for hearing along with other points. But I look at 375 on the condition of the government. Next, young my lord, 393. Approval granted. It's in volume 2. They get much more point they get BDA.
So who appears for BDA?
BDA will along with other landowners, my grievance has to be addressed. But the condition of 393.
No, that order is already there, right? That your grievance should be examined representation to division bench order.
Yes, right? It includes my case also. No, the BDA is not considering because they have come to my property house before the committee is consulted. They are coming to.
So you supply a copy to the council for BDA. We will see.
Yes.
You just supply copy. Who appeared for BDA? Mr. Krishna. All right. You supply copy.
Yes.
We'll take it up, Mr. Holla, when Thursday, Friday, whenever you want. Or you serve a copy. He can take out hand summons, right, to BDA. They have a panel probably. Fine. Yes. Heard. Learned counsel for the appellate undertakes to take out hand summons for service of notice on Bangalore Development Authority and to produce an acknowledgement. The list on when will you serve? Next week. What date? Next week. Okay. 9th March. Huh? Yes, Mr. Holla, 7th March is fine. Huh? 7th March 2020.
My lord, I am for appellant, my lord. Kindly pray for time, my lord.
How much time?
2 weeks time may be granted.
Okay, 2 weeks time to enable her to prepare the case and argue the same.
Much obliged. Much obliged.
The HP dealer, government advocate.
Yes. What happened? No other appeals from this judgment? I'm not aware. Yes. Yes. So this all has attained finality, right? This is what the single judge holds. Huh? Huh?
Those lands have not been acquired.
No, but what it has been said that validity of the notification has already been upheld, and the Supreme Court directed the state government and BTA to issue final notification. Issue then.
Second, it should be notified because there is no time limit for that one, except 5 years. So that on that basis, you are.
No, but this is a finding. Please come to para 21 in page 237. That not only the notification but the scheme has also been upheld by the Supreme Court. Page internal page 215 of the judgment.
Yes, sir.
Order passed by the single judge, para 21. Last 3 lines.
Number 21.
21 last 4 lines. Further, the apex court. Please read. Then para 22.
Deleting any portion of the land, don't depend on that. their property. There are only surrounding land of 1 lakh hectares. The second aspect is the horticulture. Actually, able to be crops. That aspect nowhere has been considered by the land. Lot of these photos are produced.
So what is your contention that it is a horticulture land?
Yes, photos and also
Fine, fine. For horticulture land, therefore, can't be, has to be dropped from the notification.
page number 315.
No, fine. Why should be dropped? There is a notification.
And not from my land is not seeking any notification.
No. There is a notification of the government that horticulture land should not. Where is that? Is there a notification or a judgment? What is it? That's what we are saying. What is that circular? Dated? No. Circular, tell us. What is the circular? Dated?
Other cases from case has been dealt with properly.
All right.
Yes, you are. And that case drainage has been issued by the
What else? What else? So this is a horticulture land. Therefore, in view of judgment of Supreme Court in Bondu Ramaswamy, it has to be excluded from final notification. Cannot be acquired. This is number one. What else?
There are two aspects in this case. One is in and around the land. In and around my land.
Yes.
No land has been notified for that.
No land.
No.
Surrounding land not acquired.
The second aspect is agricultural land you are asking, cultivable land you are asking, so that when it has been not acquired similarly or some other lands in same date, there is Ramgam land, there is discrimination in acquisition of the land, so that this petition start.
That one. Yes. Eternal page
11.
11.
Running page 11.
15. Yes.
From bottom third line starts.
Ah.
And the act of the respondent to become use of the land and submitted the preliminary notification. Not doing the whole land control the land comprising they have to control on the instead of doing so, only you can't choose the land was selected with the respondent money. The rest of the land are acquired either in the name of big deeds, high-end officers, and local leaders. There are several properties situated. There are about 1, 3, 4/1, 10, 14/8, 3, 10, 20, 16, 17, 20, 24/2, 28, 38, 39, 42, 52, 55, and 70 are not being acquired. They get that. It's clearly the last year of land government is still left. I said the entire acquisition of land is only if only 4 individuals who have no political background are not related. The land has been acquired are all fertile and potential land. For me, those land depending upon the it has not been properly answered.
Yes.
Same place land has been not acquired, then we give the benefit of the same to this.
Yes.
Right. So that I am sitting only to the tax.
Yes.
Not more than this.
That's all.
Yes, sir. It's only two months that I am.
All right. Thank you. We consider.
And BJ is also not explaining this. Either the tripod or also in this. The contention right going.
Yes. Which volume? Volume, you said it.
2010, volume 7, to SCC 129.
Ah. Which para?
Number 10, what is the division rate has been stated, it has been incorporated in the circular. Then you are asking the honorable court taking paragraph 135.
Para 135. Yes.
Only remaining about 20%, 30% of the land acquired through not LTGS, but in different parts of the market. What can be done with the applicants? Can you for only development can provide the hazard and irregular growth? The power of religion and trial exercise responsibility and stable and reasonable, which they have with the already development. And also hazard and irregular growth and create a discontent among the society. But what we need to have
Yes.
Anything you would react.
Discrimination, irregularity, both initial, and they are also required only that regard to the nature of religion. The acquisition of land do not harm continuous and contiguous living, and acquisition of small extents of surrounding that by large terms and unacquired land and lands which have been omitted from the development. The development of the court is not be remedied.
Yes, yes.
By issuing series of
Para 135. Take out 135 para. Yes. At home, right? My lord. I just you had sent it home, no? Contact and all that. This is new one. Para 135. Yes. All right. Yes, yes. Go ahead. 139. Yes.
The land was situated within the building. That was totally built up. The land was building construction, charitable institution and the RBS. The lands are used for nursery. The lands are running with practice or and you are similarly treated at adjoining lands which are not notified for acquisition. This is what I have told you.
Yes.
So on that basis, you are asking the Honorable Court to, we have been concerned with the Honorable Supreme Court in the same guideline as approach by adopted by the Supreme Court. So the lands are not being notified. So that I want to, one is the land is not notified. The other is when you have not notified the surrounding land, then I should be giving the benefit of the fact non-acquisition of it.
All right.
Tax in also what are the lands are left out
Yes.
without any reason. And that's a good the learning single is not. And taking into consideration this aspect you are asking my land.
Thank you. Yes. Next.
39.
Amendment. Any objection? Amendment. We'll allow that amendment. Mark the president. Heard on IA 1 of 22. An application for amendment taking into account the nature of proposed amendment and for the reasons stated therein, same is allowed. Let amended petition be filed within 1 week. List on 7th. We will not declare that the provision is ultra vires on 7th. He is only praying for interim relief. You have, by all means, you can oppose it, right? 7th. No. Still, this is 7th. After we will see after 7th March if they seek adjournment. They are entitled to the breathing time, right? You see, I mean, so 7th of March 2020. Second respondent number 2, Mr. Deshpande. Yes. No, your name is there. Your name is there, right? What? Acha, yes. Let a copy of amended petition be served on respondents. Yes.
Party, Srimati Deena PK.
Appearing for the petitioner, my lord.
Yes, madam.
My lord, praying for adjournment, my lord. A
Today
petitioner
you are praying only for adjournment, madam.
My lord, senior is
You
not.
made us busy yesterday evening. We all of us, both of us, were going through the files. You should have told us, told the court officer that I am going to seek adjournment in all cases. Ask judges not to waste time.
Sorry, my lord.
We went through all your files and you are just praying for adjournment for nothing at the drop of the hat. If we may ask why? Why adjournment? Supposing if it is not adjourned, then what happens?
My lord, sorry, my lord, praying for adjournment, my lord.
So why?
Senior
You
is
have not told
available.
us.
Senior is not available.
See, in this era of appearance through video conferencing, even if your senior is in US, he can appear. Right?
Sorry, my lord.
He need not remain present in Bangalore every day. We have lawyers appearing before us from Delhi, Bombay, Mumbai, and Chennai. Everywhere they appear. It's not necessary. If it's not in Bangalore, there is no ground. One ground for seeking adjournment has been deleted, madam, on account of this video conferencing, right? From that book of law of adjournments, this ground has been deleted. You know that law of adjournments, so that ground is no longer there. Find out something new. Like he is feeling feverish, so he is in quarantine, but still he can appear, no? Yes.
Station where you don't get internet.
Yes. Yeah. Yes. So my lord has come to your rescue. You should say that he has gone to a station where there is no internet. Gone to a remote area in Karnataka, fed like. So what is this, madam? Be serious. This all not fair. Not fair to the court. These proceedings are being live streamed. Your clients would say, what justification have you given them for telling that we will seek an adjournment? Supposing if your clients are watching the proceeding, what will happen? All right, praise for adjournment on the ground. Yes. They are listed today, right, madam? This is 16/4, right? 16/4. What is it, Mr.?
Compulsory.
Acha, compulsory service. So you have to file objections, madam.
Serial number 49 and 52.
No, so have you want to file objections or not? You don't want. Fine. Which date? All right. Yes.
May I know, my lord?
Write her name. What's her name?
My lord, serial number 49. Serial number 40.
One minute. We are at 40. We will definitely reach 49. Don't worry. We'll definitely reach. 40 is what? Who was appearing? 40. Council prays for adjournment on the ground. Mark everybody's presence. Learned counsel for the petitioner prays for adjournment on the ground that the arguing counsel is not available. Is out of station. List after 2 weeks. Along with WA number. Yes, madam. Now. WP number 49.
Yes, my lords, 49 and 52
WP
or
number 49
and 52, my lords.
52. Right.
Similar matters, my lords. These
Fine.
pertain. Yes, my lords. There are batch matters, my lords, which have been already wherein the notice is been issued by the Honorable First Court.
Right. Yes.
And my lords, they may be connected to that, my lords. May I give the number, my lords?
Please.
WP number 23258.
Number this 4952 as well as WP number. Yes, madam. Now speak.
23258 of 2021, my lords.
Yes. Next. That's all.
They may be connected. My lords, notice to be notice, my lords. Maybe I may be permitted to serve copy on the respondents, my lords.
Yes. Fine. So next 41. 51. 51 also. 49, 51, 52, and whatever number she has said.
23774 and
237. 21 and 21. Yes, after 2 weeks. In the meanwhile, it will be open for respondents to file objections, if so advised. Yes.
Number 40, 41.
41 are appearing for the petitioner counsel. Lord,
yes.
This is, my lord, section 18 capital B of the Karnataka Cooperative Societies is challenged.
You say chapter 9 is no longer there.
No longer
That's
there.
why.
Yes.
Fine, issue notice.
Then, my lord, the identical question I sought for an interim order is also there in connected matter. Same may kindly be granted.
Which connected matter?
Connected matter 50036 of 2019.
50036
of 2019. 8292 of 2020. 9597 of 2021. 9597 of 2021.
List along with WP number 5003 bar 2019, 8292 bar 20 and WP number 9597 bar 21. For prayer for consideration of prayer for interim leave on whatever Monday, next Monday.
Very well.
Next Monday is what?
50036, my lord. It is not
36. No, 36.
Very well.
We have got it right, Mr.
I confused.
Yes.
I confused.
Why don't you come to court?
I will come in next week.
You are a young man. Man, you should come to court now. COVID is over.
I am coming, my lord. No issue.
You are coming, no? Yes.
I'm eager to come there.
Eager, yes. Like all young men. Yes.
Lord, I appear on behalf of the petitioner. Lord, the question that arises for your lordship's consideration is as to whether, my lord, a trading platform, a platform, my lord, where goods are not traded, but
we will issue notice.
Yes.
Mr. Raghavan, learned senior counsel, heard on the question of admission, issue notice on admission as well as interim relief.
Yes.
Joseph Anthony, government advocate. In order dated 22nd December, the lordship is pleased to grant an opportunity to amend the prayer number. The further application, IA one of the application filed by the prayer.
Yes, madam. What do you say?
Small error has been rectified.
Yes, madam. What do you say? Mark the presence heard on IA number 1 of 22 after taking into account the nature of for the reasons signed therein, same is allowed. Amended petition be filed within 1 week.
44.
I am appearing for respondent BBMP membership. I have for 2 weeks time to file my statement of objections. They have challenged the constitutional validity of Rule 3.9 of BBMP building bylaws.
Learned for respondent number 2, praise for is granted 2 weeks time to enable him to file the objection. Please wait 1 minute, Mr. Yes, ma'am. Yes. For another 10-15 minutes extra. Invitation will be required. And that thing is done.
Whatever possible I did there, I carried it over here.
What's the name of the council? Mr. Coffee. This was 38. In this, write her name. No, who was appearing for? Nobody was appearing. She was appearing. What AGA for respondent number 1. In this intra-court appeal, the appellant has assailed the validity of the order dated 19th of November 2021, passed by learned single judge in a batch of repetitions. In WP number 3945/2021, which was decided along with connected matters. Paragraph. Facts giving rise to filing of this petition in nutshell are that the appellant claims that as per the appellant, land measuring survey number 10/3 measuring 3 acres and 32 guntas, including 7 guntas of kharab land, is the ancestral property of the 7 guntas of kharab, as well as land bearing survey number 57/1A measuring 26 guntas are the ancestral property. What is ancestral? This is self-acquired.
First one is ancestral.
All right.
Second one is
So the case of the appellant, that land bearing survey number 10, you have written 10/3 measuring 3 acres, 32 guntas, including 7 guntas of the 7 guntas of kharab, is ancestral property of the appellant, whereas land bearing survey number 57/1A measuring 26 guntas belong to the appellant. The appellant and one Tika Vairappa were in cultivating possession of the land. Full stop. The appellant, it is the case of the appellant that appellant has planted trees on the land in question. Full stop. A preliminary notification under section 17(1) of the BDA Act, Bangalore Development Authority Act 1976, was issued on 30/12/2008 for acquisition of the land in question, along with several other lands for formation of Dr. K. Shivram Karant layout on 30/12/2008. Full stop. The appellant filed an objection to the aforesaid notification. Full stop. Paragraph. Thereafter, the father of the appellant filed a writ petition, namely WP number 23599/2015, which was allowed by a bench of this court by an order dated 6/11/2015. Full stop. 15 and preliminary notification issued by the authority, Bangalore Development Authority, was quashed. The appellant thereafter made a representation on 16/1/2016 to respondent number 2 to the Commissioner, Bangalore Development Authority, to issue no objection certificate to the appellant. Full stop. However, the aforesaid representation failed to evoke any response. Thereupon, the appellant filed a writ petition, namely WP number 123/2017, seeking the relief of issuance of NOC. The aforesaid writ petition was disposed of with the direction on 18/4/2017. 17. Full stop. In the meanwhile, the issue with regard to validity of the preliminary notification was adjudicated by the Supreme Court wide judgment dated 3/8/2018, passed in SLPC number SLP 7661-63/2018, connected with SLPC number 10216-10218/2018, as well as SLPC number 10283/2018, wherein the appellant was a respondent. Full stop. The Supreme Court, upheld the validity of the preliminary notification as well as the scheme framed by the Bangalore Development Authority in respect of entire land measuring 3546 acres and 12 guntas, which includes the land of the appellant. Full stop. Thereafter, full stop. The Supreme Court further directed the state government and the BDA to issue final notification under Section 19 of the Act without excluding any portion of the land from acquisition, by coming to definite conclusion that there was no scope for exclusion of any land in the ultimate final notification. Full stop. In pursuance of the liberty granted by the Supreme Court, the authority issued a final notification dated 1/11/2018, which included the land of the appellant as well. Full stop. The paragraph. The appellant stated the validity of the aforesaid notification in a writ petition before the learned single judge. The learned single judge, wide common order, passed in WP number 3495/21, along with connected writ petitions, has dismissed the writ petition inter alia on the ground that since the validity of the notification has already been preliminary notification as well as the scheme has already been upheld, the grounds pertaining to challenge to the aforesaid preliminary notification as well as the validity of the scheme cannot be permitted to be urged. Full stop. In the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant submitted that the land in question are agricultural land in question are horticultural land, and therefore, in view of decision of the Supreme Court in Bondu Ramaswamy versus Bangalore Development Authority 2010, bracket close 7 SCC 129, are deserve to be excluded from the purview of the notifications issued under Section 17(1) and 19 of the BDA of the Act. it is also urged that the surrounding land has not been acquired. Paragraph. We have considered the submission made on submission made by learned counsel for the appellant and have perused the record. Full stop. Admittedly, the Supreme Court has upheld the Supreme Court has not only upheld the validity of the preliminary notification, but the scheme framed by the Bangalore Development Authority in respect of the entire land measuring 3546 acres and 12 guntas, which include the land belonging to the appellant. Full stop. The from the order of the Apex Court dated 3/8/2018 passed in the aforesaid SLPs, it is evident that the Supreme Court that the Apex Court has directed issuance of final notification in respect of entire extent of land notified under the preliminary notification without excluding any portion from the final notification, any contrary order or direction which would have the effect of quashing or excluding, stroke dropping, stroke deleting, effect of quashing or excluding, stroke dropping, stroke deleting any portion of land from the final notification. Full stop. Therefore, the assertion of the claim of the appellant for releasing the land from the purview of the notifications issued under section 17(1) and 19(1) of the Act on the ground that the same is a horticulture land and the surrounding land cannot be and in view of the fact that the surrounding land has not been acquired, cannot be entertained in the present proceedings. The learned single judge, in our considered opinion, has rightly refused to entertain the writ appeal for the writ petition. For the aforementioned reasons, we do not find any merit in this petition, this appeal. The same fails and is hereby dismissed. Next question. Yes. Yes. Mark the presence. Learned additional government advocate 45.2. Learned additional government advocate submits that an affidavit shall be filed on or before Thursday. This is what? 3rd March 2021. In view of a forces submission, let these petitions be listed on 3rd March 2021.
My lords, would your lordships consider extending the interim order, my lords? Your lordships have given me interim order.
Yes, interim order shall continue.
Please, I'm very grateful, my lords.
Oh, we can make out from the national flag that you are appearing from Delhi. Huh?
Yes, my lords. I'm sorry, I'm not physically there. I promise to be there next date, my lords, physically.
All right. No, lighter vein, Mr. Yes. Okay.
Grateful.
Yes.
46. Sri C.V. Kumar, government advocate.
Morning is there for it.
Adjournment. Praise for adjournment. List after 2 weeks. What adjournment? Not well. Praise for adjournment on the ground that arguing counsel is unwell. List after 2 weeks. Yes.
47.
Yes.
Lord, I am instructed to appear at item 47.
Yes.
Lord, the number of reliefs which you have sought, including the declaration about the validity of the definition of service in the Finance Act. Lord, may I with your lordship's approval, Lord, a so-called is issued to me at page 37, page 39. Lord, if your lordship be kind, I'm sorry, lords.
Long back on 30th April 2020.
No, no, there's a 21st October 2021 show cause on page 39. Verse.
All right.
But Lordship has got WP 2248521.
Yes, yes, 22485.
Yes, but the show cause at page 39. It's 21st October 2021.
Yes.
But it concerns the levy of service tax on the land which I have given to a developer for development. And what our contention is that by virtue of the definition of the service itself, at page which we have reproduced at page 5 of the petition, WP.
No, Mr. Counsel, what we would like to know is that you have challenged the validity of section 55BB.
No, but I have challenged the validity of section 65B 44.
That's what we are telling you.
Yes, my
BB 44 of the Finance Act.
Lordship, please.
So, what ground?
No,
and
ground
what happens
is, no, ground is that if your Lordship will can see page 6, 5 for the minute definition. But if your Lordship will see,
after
paragraph,
putting para 5 page, come to page 7.
But come to page 6 for a minute, then I will come to page 7. If your Lordship do not mind. On the top of the page 66, what is excluded is a transfer of, your Lordship may kindly see A1 on the top of page. Page 6, top of the page.
Yes,
transfer of title in the goods or immovable property by way of sale, gift, or in any other manner. Your Lordship has seen that?
Yes.
Our contention is that when I give my land to somebody for development, it ultimately amounts to transfer of immovable property, because ultimately development will take place and the property will be transferred to the ultimate society or condominium which will be formed by the purchaser of the various units. The department contends that this only concerns with the absolute sale of the property. Therefore, our submission is that under the list 97 of article, the Constitution, the levy is only on service. When I transfer my land, I give right to somebody to a development of the right. Lord, may I request this meet with your Lordship's approval? Lord, we have raised number of contentions, including the validity of the definition of service. If it meets with your Lordship's approval, my Lord, I will go back to the learned commissioner who issued a show cause notice to me.
No. First of all, you tell us on what ground you are challenging the validity.
On our ground is that under the Constitution, the service tax is levied only on service, not on the sale of land or transfer of land by way of development rights. That is our contention. Because under the Constitution, the service cannot be extended to the
Mr. As we understand,
yes, my lord.
Subject, of course, to hearing you.
Yes,
we are trying to make ourselves clear. I mean, what we are thinking at this point of time, that if a validity of any provision is challenged, right?
Yes, my lord. Yes.
In our opinion, it can be challenged principally on two grounds. That
yes, my lord.
It has the legislature enacting the law has no legislative competence.
Yes.
And secondly, it is in violation of fundamental rights guaranteed under the Constitution of India, Chapter 3.
Yes, my
From
lord.
paragraph 6 to 8 of your writ petition, we do not find any of the grounds.
Yes, my lord.
You have not said that the Parliament did not have power to enact the amending act. You have not said that, except for you have not even said that it is violative of this thing, fundamental rights.
I've said it's arbitrary and violative Article 14 in my ground for copy. Look,
No,
first ground on page 23, if your Lordship will see.
Para 5, 6, and 7.
No, those are the facts. The grounds are set out from page 22 onwards.
22.
Yes, and if your Lordship will see 23, paragraph 51. But our submission itself is that under entry 97, list 1 of the Constitution. Page 26, it should be running page, if I'm not mistaken.
26. Arbitrary, discriminatory. How?
No, kindly see first paragraph 51.
Yes.
But our submission is that under entry 97, list 1 of the Constitution, the Parliament has power to levy tax on service. And therefore, in the definition of service also, they have excluded the sale of immovable property or transfer of right to the immovable property. Now, they want to levy tax in this present case is the transfer of my land by way of a development rights. Therefore, our contention is that it is beyond the definition itself if it is construed to mean that the transfer of development right also be considered service, then it is arbitrary and violative Article 14. That is the submission which you are making. And 2 points.
That perhaps you should invoke the principle of reading down, right?
Yes, I have said so. I have said so.
Validity.
That I have said so also, my lord. That it should be read down to mean that it will not. Yes, yes. That also, my lord, if your lordship will see the prayer. At page 34. Page 34, prayer 1. Lord, your lordship has already issued a notice. Lord, may I request this? Lord, my submission was this. If it meets with your lordship's approval. Lord, the so-called notice is issued by respondent number 2. Lord, if your lordship consider kind enough to consider, I'll keeping all the contention open, let him adjudicate and pass the order within 4 weeks or 6 weeks, whatever reasonable time your lordship may feel. Treat my so-called petition as a reply to so-called notice. Keep all the contentions open. I'll go before him and I'll come back if he passes an order adverse to me.
Predicament is nobody is appearing for respondents.
I appear for the first respondent, my lord.
Oh.
Second respondent notices.
We were looking for you. You should have said.
But your respondent number 2 is served. My instructions are
1 and 2, both you are appearing, Mr.
No, my lord. Mr. Jeevan Nirgal is appearing for the second respondent, my lord.
Jeevan, where is Mr. Jeevan? Mr. Yes, madam. Where is Mr. Jeevan? On his way. Oh, legs. Oh, we thought he is on his way to this court.
Lord, may we request to keep it back?
We tend to think positively, Mr. Sandeep. Yes. So
could it be taken up after lunch, Lord, if it is not inconvenient?
Yes. Yes. Pass around, it will be taken. Please be
Lordship. Lordship, please.
Next.
Number 48, Sri D. Nagaraj.
Basically reading now, nothing interpretation. Which one? 54. 48. Learned additional government advocate praise granted. How much time, madam? 2 weeks. In 3 weeks time to enable her to file objection. Yes.
Number 49.
So 49 is done. 49, 51, 52. 50, all 50.
Number 50. Mahesh, yes.
Several matters are pending, right? Entertained. Issue notice. All right. Interim order granted on earlier occasion shall continue. Oh, other connected matters. You should say so in connected matter. We thought that stays in operation. Mr. Mahesh, learned counsel for the petitioner issue notice. Yes, madam. So notice on behalf of respondent number 1 is accepted by Mrs. Vani, learned additional government advocate. Issue notice to respondent number 2, 2, 3, and 4. Learned counsel for the petitioner submits that the writ petition involving similar issue has already been entertained and an interim order has been granted in support of a process submission. The reference has been made to order dated 23/12/2021 passed in WP number 2021. In view of process submission and with a view to maintain parity, it is directed that no coercive action, if not already taken against the petitioner, shall not be taken in pursuance of the demand note dated 16/10/2021 till next date of hearing. All right, so where is that order? Give it. Same order. Where is it? In view of offer's submission and with a view to maintain parity, it is directed. Same this. Paragraphs. Same, yes. List along with WP number 20. Next.
Number 53. Sri Sanjay Nair, Sri S.N. Prashant Chandra. Government advocate.
Yes.
Respondent number 3, my lords.
Yes. Who has taken time? Yes, madam, you have to file objections. Who has
Yes, my lords. Request some more time to file detailed objections, my lords.
So you should say so, no? Except for saying we thought you are appearing in the backdrop of so many books that you want to argue the case. We thought like that. But he told us that you want time. Huh? Learned counsel, how much time?
4 weeks, my lords.
4 weeks. Learned counsel for respond number 3. He will be happy. No, not happy. Interim order is granted. No? No, interim order is granted, right? Already. So you are not happy with this. Of course, no. So see, Learned counsel for respond number 3 precedent is granted 4 weeks time to enable her to file objections. Interim order granted on the earlier occasion shall continue. Yes. Yes.
The issue is related under the KGS. Register with the registered dealers under the KGS Act and file the returns for the
Similar matters are pending. You better this thing. This incorporate proper grounds. They are not the grounds constituting challenge to the virus of the provision. It's there in item 55 also, right? So, Mr. Malhar Rao, you're Mr. Malhar Rao, right? Heard on the question of admission, issue notice on behalf of, all right. You are accept, no, you will accept notice, Mrs. Vani. Acha, Mr. Jeevan Jain Galgi, the rent council accepts notice on behalf of respondents 1 to 3 and press order is granted how much time? 3 weeks time to enable him to file objections. Office is directed to reflect his name as counsel for respondents. Same order, Mr. Sandeep Puligal, learned counsel for the petitioner, heard on same order question of admission notice. What stay? There's this thing, no delay. Oh, no. This is something different. You have given 56, Mr. This is nominated member and this thing. This is Mr. Sri Ranga's case. Yes.
I am for the caveator. I am for the caveator.
Yes. No.
My lord,
He wrongly gave, the court officer wrongly gave the file of 55. What interim order? Same thing, like you are challenging the provision, right, which does not provide for this thing. You say that section 16(4) of the act is, it can't override the substantive provisions like 16(1) and 2. Yes. All right. Which provision you have to file an appeal? 107. Mr. Sandeep Puligal, learned counsel for the petitioner, heard on the question of admission as well as interim plea. Learned counsel for the petitioner, line below. Please ask, madam, if you have any difficulty. Please ask. Learned counsel for the petitioner submits that that section 16 within bracket 4 of the CGST Act is a procedural provision which cannot override the substantive provisions contained in the Act, namely section 16 within bracket 1 and 16 within bracket 2 of the CGST Act, Central Goods Services Tax Act, right? Whole thing, 2017, right? It is further submitted that that an order of assessment has been passed against the petitioner, and in case the petitioner would have preferred an appeal, he would have been required to deposit 10% of the required to prefer an appeal under section 107 of the Act, the petitioner would have been required to deposit 10% of the amount of tax, full stop. In view of aforesaid submission and in the facts of the case, it is directed that in case appellant deposits 10% of the amount amount as assessed by the authority in the order dated 10% of the amount of tax as mentioned in the order dated 10/12/2021, the recovery of the balance amount under the impugned order shall remain stated till next date of hearing. Madam, 6 and 7, then issue notice where you have written beginning. Third, issue notice there. Write her name, learned additional government advocate accepts notice on behalf of 6 and 7. 6 and 7. Oh, state of Karnataka. We thought state of Karnataka, so therefore you are appearing. So then he is appearing for 6 and 7, right? So Mr. Jeevan Jain, instead of her name, Mr. Jeevan Jain, learned additional government advocate, appears for respondent 6 and 7. Then issued notice for 2 remaining respondents, right? Then office is directed to reflect. We don't know. Let him know. Appearing. Let the notice go. Issue notice to 1 to 5, right? And notice on 6 and 7 is accepted by the officers. They reflect his name as counsel, right?
Lord, in this matter,
Yes.
I've been instructed to appear for respondent number 5, my lord. I accept notice on her behalf.
See how your job is made easy by them. He is not required to even tell us what is the challenge. So you are accepting notice, right, Mr. Caveat. All right, you are on caveat. So how much time, madam, do you want?
3 weeks time, my lord.
Mr. Sriranga Larit Singh. Oh, who is appearing? Mr. Nagaran is also appearing.
No, Lord, I am appearing for respondent number 5, my lord, who was a successful candidate.
Oh,
I am appearing for respondent number 6.
Sriranga, you are appearing.
No, we are sailing on the same side.
Same side. Okay.
It's a collusive brief. If I may say so.
That's a different. That's a different adjective to which I take exception.
We were wondering how can you oppose Mr. Sriranga?
No, they are very much together.
Together, yes.
Very much together. In fact, the successful candidate has already preferred a writ petition before this honorable court.
That's what I wanted to say.
Yes. Writ petition 834 of 2022.
All right.
And did not get an interim order. Now they are trying through this.
Oh.
Yeah.
All right, fine. So nothing is being done today. Mr. H. Sriranga, senior counsel with whatever. And Mr. Madam, you heard on the question of admission, issue notice. Notice on behalf of 1 and 2. 1, 2, 4. 1, 2 and 4. 1, 2 and 4 is accepted by Mrs. Mani, learned additional government advocate. Issue notice to respond number 3. Notice on behalf of respond number 5. 5. You are 5. 5 is accepted by, what's your name, madam?
Kusum Ranganath.
Ms. Kusum Ranganath, learned office is directed to reflect her name as counsel for respond number 5. And then Mr. S.S. Naganand, learned senior counsel for respond number 6. 5. 5.
Respondent number 6.
Oh, you are appearing for 6, right? 6.
He is the caveat.
Yes.
He is Mr. Mahendra. Mahendra takes notice.
All right, Mr. Mahendra takes notice on behalf of.
I appear for Mr. Mahendra.
Yes. Learned counsel for respond number 6, place for is granted. 2 weeks time, Mr. Ravi, Mr.
Please.
2 weeks time to enable him to file objections.
Lord, could your lordships kindly direct the writ petition which I have filed to be also tagged along with this? That is writ petition 834 of 2022. It is also before the division bench.
834.
Yes, my lord, of 2022.
Yes, Mr. Ravi Verma Kumar. Yes, can we hear? Yes, madam.
It can be heard together. No issue.
All right. List for analogous hearing along with WP number 834/2022.
Please.
Now, there is an interim order, my lord, which the learned single judge had granted.
He is saying something.
I'm sorry.
Yes.
election. But by interim order,
But the caveator is there. We will have to hear him, right, before grant of an interim
No,
order.
in fact, when we moved for vacating the interim order, disclosing the fraud practiced on the court, they withdrew the writ petition.
Oh,
Yes. They withdrew the writ petition. They have come before this court, challenging the vice of the very provision which was suppressed for getting the interim order.
No, but he will have to be heard, right, Mr. Sriranga? He will have to be heard. So we are not doing anything. It will.
extended by a week when it's not submitted to the writ petition. Subject to
7 days.
7 days. That will expire tomorrow. And pursuant to the interim order, single check on 29/12/2021, not election has been held, and the council will be placed. Therefore, Lord, my request is to Lord continue the interim order and maintain status quo until the matter is heard.
What status quo? You are asserting your right to. What is going to happen within 1 week? We'll have to hear him. No, he's on caveat. Can you address us in the next week sometime, Mr. Ravi Verma Kumar?
I am ready. Even today, merits I am ready. Because
we'll post it for, he says next week, any date or till after 2-3 days, he's ready. You argue. Instead of doing this, we'll have to decide it on merits. He's on caveat. Thursday for consideration of prayer for
question of law. I am ready anytime. The court.
All right, Thursday.
But single judge has said, they can file Mr. Ravi Verma Kumar's client can file an application for restoration.
What restoration?
Restitution of his rights. They want a declaration that she is the successful candidate.
No, that's all right.
Eliminating my vote.
No, what we are trying to tell you, Mr. Sriranga, is that we will have to decide the question of interim relief after hearing the parties. They are on caveat.
Seeking a mandamus against
and Thursday we are fixing. Whatever you wanted day after. Tomorrow is a holiday. Nothing will happen tomorrow. Right?
No. In the main matter, interim order is not granted. The successful candidate has approached this honorable court.
No. What we wish to tell him is that you will have to be heard since you are on caveat before you pass any order.
Anytime
so,
the court
to tell us day after. He is ready. Nothing. Tomorrow is a holiday. Day after tomorrow we hear. That order operates till tomorrow, right? Day after tomorrow we hear you. He is ready as on today, but we have 2-3 matters.
That interim order is a nullity.
Child custody and this thing, students' admission. That's why. So don't you think that your matter comes thereafter? Child custody. Fine. So day after. Mister, you are ready, Mr. Kumar? Day after.
I am ready.
Third, fine. Third. So praise for short account, not 2 weeks. Praise for short adjournment. That's all. Then list on 3rd of March 2022.
Please.
3rd March.
Please.
But I am a successful candidate.
For consideration of prayer for interim relief. Yes, Mr. Nagar.
I am the successful candidate, my lord. By virtue of the interim order granted by the learned judge, my lord, I was elected and I am holding office now for 3 months now.
Yes.
My anxiety is that should not be disturbed till the lordship hears it, because there was an interim order operating throughout. I filed a writ petition. The learned division bench, my lord, called for the writ petition papers before the single judge.
So we don't think how that position would be disturbed by Thursday. He said we were ready to take it up on this thing. Wednesday, day after. Tomorrow being a holiday.
Please, ma'am.
So
no, I
only can fix it day after also. You said Thursday. So then that's why we have fixed it for 3rd March.
Very well, ma'am. Please.
We don't think anything happens to you like this manner.
Please.
Nobody dare touch your client, Mr. Nagaran. It is so soon. And when the matter is sub judice, right?
Please, ma'am.
All right.
they have produced a lot of material to show about how Tahsildar was mishandled and physically abused, car was damaged and all that. There is apprehension that they will got some. Some status would be maintained.
No, what I mean, see, you basically, I mean, as we have understood broadly, I mean, that you say that you are challenging the validity of the provision on the ground that nominated member should also have a right of franchise, right?
Yes, yes,
That's
challenge
it.
the constitutional validity of the constitution.
Validity.
Of the constitution itself, Article
No,
243.
we are just trying to understand what is the threat perception of the petitioner and what your clients would do, Mr. Kumar. Yes.
No, we are
for
not.
sake of brevity, we are, though your name is very good, but for sake of brevity, we are addressing you as Mr. Kumar.
Welcome.
So what is the threat perception? That's what we are trying to understand. If Thursday comes up, what your client is, this thing would do by Thursday.
No, these petitioners have no relief whatsoever. They are proxy. They're now in no way benefited. Yes, they are not the elected people.
But my petition
nominated. Yes, that's
nominated people who exercise franchise, taking an interim order, suppressing the fact that they did not have the right to vote.
All right, to Thursday, Mr. All right, Thursday.
Please.
Yes, sir.
Appellant lordship in this matter. It is a It is a matrimonial matter, my lordship. The wife appeal, my lordship, against the grant of decree of divorce. My lordship.
Take to appear respondent in this case, my lords.
So yes, admit.
I'm on KV, my lord. Yes, my lord.
Notice on behalf of respondent is accepted by Mr. Rashmi. No, what's his name? What's your name?
Siddhavir C, my lords.
Learned Counsel Office is directed to reflect his name. Heard on IA 1 of 22. What is it?
My lordship, I pray for the stay, my lordship, of decree of divorce.
As it is, he can't marry. No, you have filed the
No, my
appeal.
lordship, my lordship, there are instances, my lordship, before this honorable court, they marry and bring the second wife.
Within 30 days.
Lords,
yes, Mr.
Yes, my lords, let the date may be fixed on IA, my lords. I am not third copy with the memorandum of appeal, my lords.
We will have to then stay.
Whether
your client is marrying, contracting marriage within
that
1 week.
That has been, I mean, allowed, my lords. So the decree of divorce has been granted in my favor on the ground of desertion. And yes, my lords.
No, that's all right. Decree has been granted. That's why he has a right of appeal under the statute. He's exercising that right. She is exercising that right. The only question is, since you want time to file objections, right?
Please, my lords. Please, my lords.
So, whether your client intends to marry within 1 week, that's what we ask you. Simple question.
No, my lords.
So otherwise, you have to stay this decree. All right. So you are not. How much time do you want?
2 weeks, my lords. 2 weeks time.
Learned Counsel for respondent praise warrant is granted 2 weeks time to enable him to file objections. In the meanwhile, operation and effect of the impugned judgment and decree dated 10th of January 2022 shall remain state. Record also, admit and then record.
Much of
Yes. No. What's it doing? Cerebral palsy, right? So, benchmark. So central government says 40%. So
the NCC has declared it is not road attraction. Income they know. So, I think the board the government has to send in from the board. But it's not they give the same percentage.
Right. All right. Dispose. Oh, orthopedic surgeon and which board, Mr. Government will constitute. Yes, madam. Right, we have passed our order with similar order. Come here. We passed several orders. Orders have been passed. Interim order or final? Final. In the blank slot, give a form. I will say. All right, dispose of this. Yes, madam. So state government will constitute a board. Within how many days, madam? Within 3 days. And when will you appear? Then he will appear on a date to be notified by the board. And when will you then, this board will, this thing, submit the report? So, and then you will act on that, on the recommendation. All right, you write, yes. In this writ petition, please type it today, just now.
Yes.
And upload it. What's your name? Mark the places with consent of the parties. Matters heard finally. In this writ petition, comma, the petitioner inter alia seeks a writ of mandamus directing the Karnataka Examination Authority to conduct re-examination of the petitioner by an independent expert committee to ascertain the physical disability from which the petitioner is suffering. Paragraph. Facts giving rise to filing of this petition briefly stated are that petitioner completed her pre-university course conducted by Central Board of Secondary Education in the year 2021. Thereafter, she appeared for national eligibility cum entrance test. Full stop. The results were declared. Results of the aforesaid examination were declared on 1/11/2021. The petitioner is a general category candidate and secured a rank of 1609. Rank of 1609 under the person with disability quota. Full stop. Paragraph. It is the case of the petitioner that she is suffering from specific disability, that is locomotor disability. Full stop. The with cerebral palsy, CELE, palsy, PALSY, palsy. Full stop. So when did the state board examine her? Date has not been given. When did the state board examine you, Mr.? 3/1/22. And when is this thing central board? Page. No, which one is first in point of time? That's what. Central board. Page. Hey, Mr. Page. You can't even. 18, 19. 18 is disability board. 18.3. No, you said central board, state board. That's why. Page 9. 17, 11, 21. So this is what. This is by regional medical board. All right, Chennai. All right. Yes. The petitioner was examined by which board, Mr. Page 18. No, so then, so what is there? There has to be 50%, right? So it's 50%. Then which is the other one? What basis she is claiming that she is 40%? There, please, 50% is eligible. So she is eligible, right? So then why you should not accept this disability? Achha, state board. All right. So all right, fine. Now what? Yes. So what have you written?
It is the case of the petitioner that she is suffering from
Full stop.
Petitioner examined
by petitioner was examined by which board, Mr. Ramesh? No, Annexure DD was examined by Regional Medical Board, Rajiv Gandhi Government Central Hospital, Chennai, and the aforesaid board found that the petitioner suffers from disability to the extent of 50%. Full stop. However, it is the case of the petitioner that even though she is eligible to be considered under the physically what she is entitled to be considered under the category, namely person with disability quota. Yet, as per the guidelines framed by as per the regulations framed by the Medical Council of India, however, she has been denied the benefit by the Karnataka Examination Authority. Full stop. Paragraph. On the other hand, Learned Council for Karnataka, additional comment. On the other hand, Learned Council for Karnataka Examination Authority submitted that the petitioner has to be examined by the state board to ascertain her disability and ascertain her disability, and if the state board certifies the disability of the petitioner and if the state board finds the petitioner eligible, the Karnataka Examination Authority shall give effect to the recommendation of the state medical board. Full stop. Learned additional government advocate, continuation, right? Learned additional government advocate appearing for respondent number 1 fairly submits that the state government shall constitute a board within a period of 3 days, and the aforesaid board shall examine the petitioner and shall give and shall certify the percentage of disability. Paragraph. In view of aforesaid submissions and in the facts of the case, we deem it appropriate to dispose of the writ petition with the direction that in case that the state government shall constitute a board comprising orthopedic surgeon as well as neurosurgeon to ascertain the disability of the petitioner. The board shall notify a date. The said board shall notify a date of appearance to the petitioner. The petitioner shall appear on the said date before the board. The board thereafter shall examine the petitioner and shall issue a certificate with regard to her disability. Needless to state that in case the petitioner is needless to state that the Karnataka Examination Authority shall give effect to the recommendation by the state board. It is made clear that this court has not expressed any opinion with regard to merits of the claim of the parties. Accordingly, petition is disposed of. And then what is get it uploaded today?
Yes.
Type it just now.
Yes.
Huh? No, that's what we told her to type it just now. It will be uploaded today, madam. Definitely.
Passed over matters.
Passed over. Which is?
Chamber state.
One minute. 2 minutes. Just wait. These are to be heard finally, right? You call it just 1 minute. And here 16 also to be called. Just wait. Other one, any other password?
25.
1 minute. 19.
19. Sharavana, yes. The T. Teshagiri Rao.
List next week. 19. List next week. Fine.
25.
Yes, 25.
For the appellant question.
He is not there.
Next week.
Mr. No. Condone the delay.
Yes.
Heard on. Mark his presence. None for respondents, even when matter is called in second round. Heard on IA number 1 of 20. An application for condonation of delay. Line below. Despite service of notice, neither anyone has appeared on behalf of respondents nor any objections to the application for condonation of delay have been filed. Full stop for the reasons assigned in IA number 1 of 2020, which is duly supported by an affidavit, we find that sufficient cause for condonation of delay of 230 days in filing the appeal is made out. Accordingly, delay in filing the appeal is controlled and the result IA 1 of 20 is allowed. Fine. Let the appeal be listed for orders on admission after 1 week. Yes.
32. Sri Hari Government Advocate.
None for the appellant, even when the matter is called in second round. Awaiting appearance, line below, awaiting appearance of learned counsel for the appellant. Hearing of the appeal is deferred. List after 1 week. Does not serve. Why? All right. We know that some hospital, right? The learned single is not amenable to Article 12. No, but see, the problem is, madam, if we pass an order, we will be faced with an application for recall on the ground that the order has been passed in violation of principles of natural justice. What to do? We have learnt it hard way in 3.5 years in this court. That's why one opportunity. Next date he doesn't appear, it will go. Yes.
Number 33. Sri V.S. Ugrappa. Sri Vamshi Krishna. Sri A. Nagarajappa.
How much time will you take, Mr.? Yes. No, he is arguing for interim relief. The notices have already been issued. You all have to file objections. He is arguing for interim relief. We will decide the question. So what interim relief, Mr.?
Passed by the Deputy Commissioner.
What is the date of your?
26th of July 2021. And the order passed by the learned single get dated 8/9/2021. At page 16, my lord. So wherein, my lord,
No, it should be stayed, right?
It has to be stayed.
So then if it is stayed, what happens?
Appellant will become a member of the town panchayat. So she has to represent the voters, my lord, since in view of these orders, my lord, she lost the opportunity to represent them and to develop the area.
Yes.
So, the impugned orders passed by the Deputy Commissioner, it is without considering, first point, there is a delay in considering the petition. So in fact, as for the provisions of law, within 60 days, it has to be disposed of.
Yeah.
wherein they have taken 154 days. Second, no opportunity was given to the appellant to adduce the evidence and to place the medical certificate and other things, my lord. Second thing, my lord, is the whip which was issued by the sixth respondent. So without authority of law, in fact, A and B form was signed by the national president of the political party, that is JDS.
We got it.
Yeah.
District
So that is why,
president.
my lord,
District president has issued it and it has no authority.
no authority,
Yes,
my lord.
fine.
There are yes,
All right. What do you say? Got it. What do you say? This is interim relief. It's enough. For interim relief, you have a prima facie case. What do you say, madam? What do you say with regard to the fact that it was issued by district president and had no sanctity in the law? All right. Yes. Fine, fine. Fine. Yes, yes, yes.
And they were important point. In one place they say she was under 1 week rest, my lord. And on in paragraph 60,
Hey, Mr. He has argued only for state. Why state cannot be granted? Tell us. Yeah. All right. All right. Thank you. We'll consider the prayer for interim relief. How much time do you want to file objections? Yes, madam, you want to file in, or though it's a writ appeal, you can argue. Fine. We'll consider the prayer for interim relief. Yes. Pass an order. You want to say something?
No, my lord, in fact, there was no election at all. It was an anonymous election. The tribal lady.
Whatever.
So because of political rivalries among the members, she was victimized.
All right.
And only term is 1.5 years. So that is why, my lord, Lord Shumai kindly grant the interim relief. Then only she will continue as a member.
Yes. Thank you. We'll pass an order. Yes. That's it.
47. The next week,
Please, your lordship. My lord, I appear for the petitioners. But you know that service tax matter.
Where is Mr. Jeevan? The Council for Revenue is not there. We will take it up day after tomorrow, Mr. Council.
Very well. Very well.
Mr. Ramesh T. Learned Council.
My name is Prakash Shah.
Oh, I'm Mr. Prakash Learned Council for the Prakasha Learned Council for the petitioner. None for respondent number 2.
I appear for the first respondent, Lord.
Mr. Madan Pillai Learned Council, Central Government Standing Council for respondent number 1. None for respondent number 2, even when the matter is called in second round. Awaiting appearance of Learned Council for respondent number 2. Let the petition be listed for consideration of prayer for interim relief on day after is what?
Wednesday, my lord.
2nd of March 2022.
Grateful notes.
Obliged.
Deeply obliged. Deeply obliged.
Why? Wait 1 minute. Now only 2 passwords.
Lord, may I take your lordship leave to leave the court?
Yes, please.
Grateful notes.
Yes, in this writ petition, this is 33. Mark the presence of everyone. Heard on the question of interim relief. Learned Council for the heard on the question of interim relief. Learned Council for the petitioner submits that that by an order dated 26/7/2021, the petitioner has wrongly been disqualified to be a member of the Kortagere Town Panchayat, Kortagere, Tumkur. Full stop. It is further submitted that that the petitioner has not violated the whip issued by the party, as the same was issued by the district president of the party, which has no sanctity in law. It is further submitted that it is further submitted. It is further submitted that that the petitioner did not attend the meeting. Right? Yes. Did not attend the meeting as she was unwell. Full stop. On the other hand, learned counsel correspondents have opposed the aforesaid prayer paragraph. We have considered the respective submissions made by learned counsel for the parties. The order dated 26/7/2021, by which the petitioner was disqualified to be a member of the town panchayat, has already taken effect. The aforesaid order has been upheld by learned single judge of this court by an order dated 8th of September 2021. Full stop. Therefore, in our considered view, in case the stay of operation of in case the aforesaid orders are stayed at this point of time, the same would amount to granting final relief to the petitioner without adjudication of the rights of the parties inter se, which is not permissible in law. Line below, we therefore decline to grant the interim relief. Accordingly, the same is rejected. However, taking into account the fact that the tenure of the petitioner is only for 1.5 years, it is directed that let the petition be listed for hearing on 29th March, say 30th March 2020. Then before that, you write pleadings be completed. Whatever pleadings, if any, be completed, then say fees was list on whatever March. Yes. Now, yes. Mr. Mahesh, yes. Oh, 1:30. 2:30 we will begin. And we will not hear you for more than 10 minutes. 10 minutes you should conclude, right?
What after list number 2, first and second matter ಏನಾಗಿದೆ? Hello? Hello, court officer? List number 2, list number 2, 1 and 2 ಏನಾಗಿದೆ? Hello?
ಹೇಳಿ ಸರ್.
List number 2, first and second matter ಯಾವತ್ತಿಗೆ ಅಂತ?
ಸರ್ ಅದು ಅಡ್ಜರ್ನ್ ಮಾಡ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಗೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಸರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಕರೆದಿಲ್ಲಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಎಲ್ಲ ಎಂಟೈರ್ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಡ್ಜರ್ನ್ ಮಾಡ್ತಾರಾ?
ಹೌದು ಸರ್, ಯಾವುದು ತಗೊಳ್ಳೋದಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೋಗುತ್ತೆ ಸರ್.
ನಾವು ಕಾಯೋದ್ ಬೇಡ ಹಾಗಾದ್ರೆ. ಥ್ಯಾಂಕ್ ಯು.
ವೇಟ್ ಮಾಡೋದು ಬೇಡ ಸರ್, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ತಗೊಳ್ಳೋದಿಲ್ಲ.
ಥ್ಯಾಂಕ್ ಯು.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಕರೆದಿಲ್ಲಲ್ಲ ಸರ್?
ಅದು ಮಧ್ಯಾಹ್ನ ಬರುತ್ತೆ ಸರ್, ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆಗುತ್ತೆ.
ಸರ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಏನಾಯ್ತು ಸರ್?
49 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಮೇಡಮ್. ಅಲಾಂಗ್ ವಿತ್ ಕನೆಕ್ಟಿಂಗ್ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಓಕೆ ಓಕೆ ಥ್ಯಾಂಕ್ಸ್. ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 47 ವಾಟ್ ಹ್ಯಾಪನ್?
ಮೇಡಮ್ ಅಲ್ಲಿ ಅವ್ರದ್ದೇನು ಮೇಡಮ್ ಅರ್ಜೆನ್ಸಿ ಅಲ್ಲೇ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕು. ಈಗ ಅವರು ಏನೇನೋ ಡೇಟ್ಗಳು ಇಟ್ಟಿದ್ದಾರೆ, ಇಂತಿಂತ ದಿನ ಬರಬೇಕು, ನಾವು ಕೊಡೋದು
Court
Next week
officer,
ಅಂತ ಮಾಡಿ.
list number one,
Court officer.
serial number 47.
47 ವೆಡ್ನೆಸ್ಡೇ ಬರುತ್ತೆ ಮೇಡಮ್, 2nd March.
Okay, okay, thank you, sir.
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ತಗೊಳ್ಳೋದಿಲ್ಲ.
67 and urgent ಆಗಿದೆ. Court officer.
ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ ಸಾಹೇಬ್ರು. ಚೀಫ್ ಡೈರೆಕ್ಷನ್ ಏನಿದೆ ಅದ್ರ ಪ್ರಕಾರ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ.
Court officer. Court officer. Court officer.
ಆ ಸೀರಿಯಲ್ ನಂಬರ್
56 ಯಾವತ್ತು ಡೇಟ್ ಕರೆಕ್ಟ್ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊ. ಸೀರಿಯಲ್ ನಂಬರ್ 56.
Serial number 56 is 3rd March.
From 67 and urgent ಆಗಿದೆ.
Thank you.
67 ಇನ್ನು ಆಗ್ಲಿಲ್ಲ ಸರ್, ಏನು ಆಗ್ಲಿಲ್ಲ. ಇದೆ.
Madam, list number 2 ತಗೊಂಡಿದ್ದಾರಾ?
9 or 7th March. All will be adjourned ಅಂತ ಹೇಳಿದ್ದಾರೆ.
List number 2 ನಾ?
ಹೌದು.
Okay. ಕರೀತಾರಾ individual matters?
ಇಲ್ಲ ಮೇಡಮ್, ಒಂದ್ ನಿಮಿಷ ಲೈನ್ ಇಡಿ, ನಾನು ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀನಿ.
ಮೇಡಮ್ 65 ಫಸ್ಟ್ ಲಿಸ್ಟ್
ರೀಚ್ ಆಗ್ಲಿಲ್ಲ, ಇದೆ ಸರ್. ಲಿಸ್ಟ್ 2 ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಮೇಡಮ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಬೇಡ ಸರ್, ಬೇಡ. ರೂಪ ಅವ್ರ ಫೈಲು ಸೈನ್ ಆಗಿ ಬಂದ್ರೆ ಅವ್ರ ಕಂಪ್ಲೈನ್ಸ್ ಇವತ್ತೇ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ. ಬುಧವಾರ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಅದೇ ಅಲ್ವಾ ಇದು?
ಫೋನ್ ಮಾಡಿ ಹೇಳಿದೆ
ಡೇಟ್ ಏನ್ ಕೊಟ್ಟಿದ್ದು? ಹೇಳಿ ಅವ್ರಿಗೆ, ಒಂದೇ ದಿನ ಬರುತ್ತೆ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ.
ಇಲ್ವಲ್ಲ ಸರ್, ಇಲ್ಲ ಅಲ್ಲಿ
ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ.
ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕು. ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ 30th ಮಾರ್ಕ್ಗೆ ಫೈನಲ್ ಇರುತ್ತೆ.
On behalf of the respondent stating that he now at the petition regard dispute message in the petition and this Raja and approach.
ಅದೇ ಅವರೇ ಇದ್ದಾರೆ.
Court officer? Court officer?
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 62 ಕಾಸ್ ಲಿಸ್ಟ್ ಒಂದು ಏನಾಯ್ತು ಅದು?
ಇನ್ನು ತಗೊಂಡಿಲ್ಲ ಮೇಡಮ್, ರೀಚ್
ಸರಿ ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Sri Mahesh S, Sri Kiran Viron, SPP.
Thereafter, civil marriage over there. 82 child was born in Canada. And after the due course of time, unfortunately, the post responded got he started living his case. And not by allegation, one out by a own application to go out of Canada. He abandons the family, including the 32 child. For 1 year, the petitioner and the child, petitioner taking care of the 32 child, the girl child. And thereafter, the wife files, when the post respondent files an application before the court of holiday court of Canada for the divorce and the custody. And though she files, the honorable Canadian court found it. There is an interim order. Interim saying that one thing is the temporary access to the mother, and then restraining order against the mother's friend with whom she is living, saying that this person should not take care with the whatever. And thereafter, my lord, she induces the petitioner saying that I have to go to Bangalore, which is Bangalore, for a short time. And she gets a consent letter. My lord, as per the law there, husband has to give a consent, okay, please go and come. She induces the buyer, what and promises, and she gets this consent letter for a period of 1 month. Accordingly, my lord, she must be because airline to take on the book for a period of 1 month. After she comes there, 180 degrees, 360 degrees around. She says she doesn't want to go. And on the given date, the petitioner has to go to Canada. She files a false 480 case and then is restrained. And thereafter, she goes to family court, files an application seeking for the custody of the child, taking some possession of max. And thereafter, after we file application, it is a reasonability after the request of the honorable they gone to family court and rejected the petition, saying that this is not a good case, rather than this is not taken up. It is not the high court. The honorable high court is different from the sketching remarks, imposing costs, rejected the appeal. I have produced a copy of the appeal. Now, I'm but the committee of demands that she has to be there where it is her case. She has recently, she cannot abandon, as she abandoned the family, as she abandoned the daughter, she cannot abandon the honorable court and come down. She cannot violate the honorable court of which she has got at her instance, come here in Bangalore and violate the court and try to make allegations against the person. That's my lord. And the child, the child is a tendency. The very reason why the teacher will respond for She has changed me to right? And part of it, she has not given the other blank. I only wish some other may become later point of time. Not want to bring that to the. I know my life. But I think the very reason which is both responded, very good. Hey, they had the ability of handling child. Also, people want to go over there. He had gone there. He was there. He also joined a job. The only basic idea is to see to it that the child will get a lifeline. And child was used to that lifeline. Only why do you want to personally now tell us? I want to take back the child to Canada, give us the best education, give us the best life. And she's a Indian citizen. She has the right. As a parent, we cannot make the parents cannot make the child an appendage. Or the mother cannot shoot the rifle over the shoulder of the child on the husband. This is what parents will happen. Let the child have a good life. And as a father, my Lord, I request. The child is the victim. Unfortunate victim. In Canada, Canada is saying, Appa Amma generally puts Manavai. Means with the fight between father and mother, it is the child who will really hit very bad. So this is the helping in this case. And so this thing, father has already, the president already has an order in his favor that the child should be so much so, my Lord. The final order passed. Sorry, the order passed by honorable president. Other country passed by the vote in Canada. And there is a specific direction to the board that was to hand over the custody of the child to the father. Why? So the only thing is, what will you do? I mean, supposing you are in India, right? And you are going to see child. You will go to your workplace. Who will look after the child? Who will do the homework? My Lord, that is all 1 year. 1 year when he cruelly abandoned. This is tiny thought, man, but he was taken care. He was not there. At that point of the life of such a small child, he has taken care. And he has got such infrastructure to look after. Not at all. He will take care of this child. He will be with some other man, she has left both, and he has taken care. And also, I regard he undertakes that he will 100% the death marriage, nothing will happen. But the only problem he has to make the child not there to suffer and take that to aside with the issue. That's the only reason he is submitting the very good. That's all. Your relation with the other person, what impact it will have on your young child. You should think about the future of your child. No, if you are interested in perspective, what happens to her? Is it correct that you have left the victim? We don't know. If I was distributed and we have denied him, now the relevant date is 25th of August 2018. August 2018, the petitioner was responding along with the minor child arrival in India. And it is not being disputed that it was by the consent of the petitioner. That lordship will get an annexed here at page 105 letter, where the petitioner has given consent for the both respondents and minor child to travel to India.
You was duped, right? You told that for a short visit. So write the India on which date?
25th of August 2018. The orders of the Canadian court
really say that we are permitting you to permanently come to country, or what was the exactly?
Not a dispute that the court respondent had initiated a divorce proceedings in Canada. That means several acts of maintenance have been made out. I am not getting under which
we must say, like we have put questions to it, he is a single parent, he is an engineer, we ask questions to him. Same way, our only concern is about your partner, that what impact it will have on your young child. He is absolutely a stranger, he is not her father, and if he keeps on visiting you, and if you meet your child you stay with next year, what impact it will have on her growth as a person? That's the only concern.
But ever since the court respondent is in India, they have not been in contact. That is what I am interested in. Submission. So that issue has died. That issue has died.
So you are listing so far when you will be in Canada.
Not even in India.
And when will not you will not be in, you will have totally done. You will not be with him. So we are going to record the leave.
Now, Lord, the orders which the petitioner is relying upon is the order dated 27th of November 2018, which is at Annexure S, page 134. This is 2018. So nearly 3 months after the court respondent has come to India. And when to disclose, this is the order passed by the Court of Canada, Superior Court of Canada, Annexure S, page 131. So this is an order which has been passed by the court respondent in India. And yet clearly expressed to the petitioner that she is not willing to come back to Canada at all. And she intended to raise the child in India. That is the reason that she did indeed fight the petitioner regards and what act, which subsequently has been dismissed, and especially if petitioner was in Canada, and it was now normal. Now she has not taken up any thought. She is taking care of the child full time, and she stays with her parents.
How do you manage financially?
There are income which accrues to the court respondent. There are leases. Her lands have been leased out. Annually about 10 lakhs is the amount that she receives out of the lease amount. And taking care of the child. That's my affidavit. In fact, on the other hand, in my counter affidavit, I have stated how the petitioner does not have a job for last almost 2 years, which is an admitted fact by his own affidavit. It's a letter which cannot be
get into it. So, see, supposing if the custody is given, I mean, you are financially independent to take care of your child.
Which she's been doing it for the last 3.5 years. Not a pie has been donated or given by the father. He has not come forward even to visit the child except on 2 occasions. At the suggestion of the court, independently he has not filed a single application.
When did he come? When did he come?
On the same day, 25th of August 2018.
Why? What is?
My first suggestion is that.
No, you said on 2 occasions. Which are the dates?
2 occasions. One is July 2021. Orders passed by this honorable court in this very proceedings, where at the suggestion of the court, the child was sent Lord, he did not ask for that visitation at all. Lord. And the last was when he filed an application for visitation and as directed, he had taken the child in the mediation center. The 11th February, which the birthday of the child, he wanted to spend some time. These are the only two occasions on which the petitioner has met the child. Independently, has never made effort to see the child at all. And it is my respect to journalism. It is out of vengeance as against the court respondent, which he has been rightly so that this petition has been filed not for the welfare of the child. Yet against the court respondent. Therefore, my lord, my first respect is sufficient insofar as the Canadian orders are concerned. I would like to submit that this is the second round of litigation. The earlier petition was filed in 2019, which order your lordship will find at Annex 1. It was disposed of on 22nd of December 2020 in WPHC 25 of 2019. Now, while these Canadian orders were part and parcel of that proceedings also, same Canadian orders were filed along with the writ petition. And I request kindly see the order at Annex 1.
Written submissions. We have given 2-3 flags. Yes.
My lord, in that writ petition, my lord, I just request your lordship, just short order, my lord, as to how the court dealt, despite that order being on record. Over the second round of litigation is only on the ground whether there is just exception. The just exception is whether dismissal of my GNWC can be the cause of action in initiating the second round of habeas corpus. According to the petitioner, 2 paragraphs in this writ petition are on account of cause of action arises because GNWC has been dismissed. Towards which the petition is verbatim of the earlier writ petition. Therefore, my lord, this honorable court, my lord, has considered the Canadian court's order at page 189. Para 9, if your lordship permits, I'll read what, as observed herein, the minor child in the incident case not being in the company of the father for past 2 years, and the girl child being aged about 9 years, and the fact that she is on the age of attaining puberty, it would be appropriate. The custody has to be continued with the mother for the present, subject to the orders.
189 of the paper book is reading. 189. Petition, right? 189.
Page 189, the very first para, the court has considered the orders passed by the Canadian court. Despite which, the court has come to a conclusion that it is in the best interest of the child that she continues with the mother, subject to orders that may be passed by the family. Now, your lordship recollect, in December 2018, the fourth response, page 196, your lordship,
yes.
Para 9. As observed here in the above, the minor child in the incident case not being in the company of the father for past 2 years, and the girl child being aged about 9 years, and the fact that she is on the age of attaining puberty, it would be appropriate that custody has to be continued with the mother for the present and subject to the orders that will be passed by the family. First, my lord, this order came to be passed after, in the earlier petition, all these Canadian orders were already before the court. Yet, this honorable court took this view. The second aspect, which says, subject to orders that may be passed by the family court. The petitioner had also filed a counter claim, which is also forthcoming in page 191.
When was your this thing petition dismissed? Guardian and what fact? Guardian on the existing territorial jurisdiction. When?
2021.
All right. So thereafter, appeal has also been 2863. That has
dismissal of the said MFN, the special leave petition has been preferred, which is pending.
So dismissal.
Special leave petition number.
So when, just a minute, when was this MFA dismissed?
MFA was dismissed on. Yes.
You can tell us the date later on.
Yes.
SLP 14/12. Okay.
SLP diary number 3471 of 2022, which is filed on 2nd of February 2022. That is still pending. Now, the subject to the observation made by the Honorable Court in para 9 again, subject to orders that will be passed by the family court, your Lordship to kindly turn to page 191 of the same order. Page 191. Your Lordship will kindly see the third line of the paragraph number. Page 191. The fourth respondent has also contained a third line. Has also contained that she has already filed a petition in GN that will 6037 because the family court value for declaring her to be appointed as guardian of minor child. In which proceedings, petitioner has appeared and has not only filed a statement of objection, but has also filed an application for rejection of the petitioner on the ground of family court not having jurisdiction, but also made a counter claim seeking interim custody. Therefore, keeping that he had also sought for the custody matter, the liberty was reserved. So, mere dismissal of JNWC petition on the ground that the court did not have jurisdiction does not give rise to fresh cause of action in filing this petition is my first submission. As annexed one more part, the very first paragraph of that order at page 189 itself, where Lordship may kindly turn to 189, very first paragraph, and to direct return of the minor child to Canada as per the order dated 27th of November 2008. So all these records were there before the year. Therefore, my respective submission is the earlier discretion exercised by the Honorable Court in granting, in allowing the custody of the minor child with the mother keeping her age in mind. Lord, we continue with my humble prayer to this Honorable Court. The second one is that the child has now been in India for more than 3.5 years, except changing the school once. He was earlier in the Delhi Public School, Bangalore North, for 3rd grade, and subsequently he has been with the Vidyapit school for last 2 years now. I have produced the marks card of the child along with my counter affidavit filed on 20th of December 2021, which goes to show that she has excelled in her performance and that she has one other grievance of the petitioner or allegation was that I have made the child miss the school. But the marks card which I have produced itself discloses the number of days that I have attended and realized what the petitioner has stated.
Yes.
Well, the second aspect is the affidavit filed by the petitioner on 20th of December 2021 discloses that he does not have a job and he has been in India for the last 2 years. And I am also told that was one of the reasons as to why there was a differences amongst them when they went back to Canada after the marriage she had get misrepresented with regard to the education colleges. And it was out of the money that the mother was contributing in Canada that the child was also being. Although they get certain money for as a social security, it was the mother who was contributing to the child's education. And the admission and the affidavit filed, the letter is produced, which cannot be believed because no employer will give an option to the employee to say, we will leave over the date of joining as and when you come, we will allow you to join. So therefore, this letter which he has produced.
No, he is waiting, the employer is waiting for litigation to be over so that he can go along with the child. Right? Yes. Yes.
Well,
what else?
My second submission is The affidavit itself, when the question fell from this honorable court with regard to how the father is going to take care of the child, in the event the custody is going to be given, what has been spelled out in the affidavit is that a social worker will be appointed to take care of the child, which is forthcoming in para 8 of the affidavit, and the nanny will be appointed. So, as against the social worker and the nanny man, it's better that the child grows up with the mother.
Fine.
So therefore, and the other aspect is his mother is aged more than about, subject to correction, about 80 years. And he has also said that they will also come, and the sister is also willing to come. So therefore, the second submission is that the petitioner lacks female support system in Canada to take care of the minor daughter.
Yes.
Now, in the incident case, the minor child is staying with the mother for the last 3.5 years. She has developed roots. She has been staying with the grandparents. She has attached. They have also kind of an attachment to the child. Therefore, abruptly removing the child at this distance of time, after more than nearly 4 years, will get completed in August. Will have a psychological effect on the child. And we also inquired on the last date as to when the academic year begins in Canada. Our instructions, I am told, it commences from September. The other aspect is both the father and mother are of Indian citizenship. None of them have acquired any citizenship of Canada. But insofar as decisions are concerned, I am not troubling about it. Insofar as Nityananda's case is concerned, it was also pertaining to a girl child of 6 years old. I have produced my compilation on 9th of December 2021.
You, Mr. This practice must stop, right? You file, no, I mean, generally I am saying, not only in this case, what happens that you file the petition thereafter, both the parties, I mean, they feel like memos after memos as many times as they feel like. And then it becomes quite a job to deal with this memo dated so and so, memo dated so and so. All it should be comprehensive, right? Or you should at least prepare a paper book where everything, I'm not only this case, but generally it happens very difficult. Fine. So, where is your memo now? Tell us, please.
The first decision is
So where is your memo dated, Mr.? Then we will get it.
9th of December 2021.
9th of December. 15, 16, 11. Memo of convenience. No. 15, 11. Oh, this. Very, Mr. Natraj, where is this yellow thing? This yellow cover. Oh, yes. Fine.
SEC 454. The fact of the case is also that it was a 6-year girl child, and the Honorable Supreme Court allowed the girl child to remain in the custody of the mother. You have to kindly turn to paragraph 47 at page 28.
Yes.
In habeas corpus petition, as a court, High Court must examine the threshold of the minor is in lawful or unlawful custody of another person. So, considering the issue such as present, it cannot close the primary of none other than the actual guardian of the minor being balanced to mother. Once that fact is ascertained, it can be presumed that the custody of the minor with her mother is lawful. In such a case, only in exceptional situation, custody of the minor may be ordered to be taken away from a mother or being given to any other person, including the husband in exercise of the jurisdiction. Now, even in this court, in this decision, ultimately what is held is, even though the India is not a signatory to the convention, even if principles of comity of court is pressed, then it must yield to the welfare of the child. And this honorable court, my lord, in the earlier petition, has exercised the jurisdiction of Parents Factory Act and has stated that keeping the age of the child and the fact that she is attaining puberty, it should be left with the custody of the
Where is
father.
that?
Which is that page, no, sorry, no, the annex to Y which I referred at.
No, that's all right. Which paragraph it is said? You are telling us. We won't, I mean, we don't want to search. It is.
Courts, your lordship will get it at page, para 14, at page 24. One is, the court has noted that India is not yet a signatory to the Hague Convention.
Fine. It must yield to, where is that?
Yes, my lord, I will. My lord, 42, my lord. 42, para 42, page 26.
Summary and query.
We do not find any contradiction. The principle, the committee of courts cannot be given primacy or more weightage to deciding matters
Fine.
or for return of the child to the native. And I'll also point out the para 46, my lord, at page 28. Lordship, 3 lines. The order of the foreign court must yield to the welfare of the child. Further, the remedy of writ of habeas corpus cannot be used for mere enforcement of directions given by the foreign court against a person within its jurisdiction and convert that jurisdiction into fact of an executive court. So, principles of committee of court also must yield to the welfare of the child. The next decision that I am relying upon is at page 40. Page 40, again the full bench of the Honorable Supreme Court, Kanika Goyal's case. Here also the child was of 3 years, girl child again.
10 minutes are over, by the way, we may tell you. You said 10 minutes, it's over.
One more decision and I'll
Don't have it, there's no point in repeating. Please refer to only one decision for one proposition, like we have understood. We have, in your case only, Mr. We have dealt with all this exhaustively. We know. I have got the judgment. Our judgment, you should have given. I have got it from my staff. I have got it. We all have read it and guessed together. No. So therefore, whatever, which other decision, don't we know everything? We have dealt with it recently. You have appeared in that case. You know it.
One more decision, which is at page 105.
105.
Sarita Sharma's case.
What is it?
2003 SEC 14 at para 6 of the judgment 112. In the middle of the para 6 number.
Yes.
Ordinarily, a female child in the middle of the para number.
Yes.
Ordinarily, F. Note F. Ordinarily, a female child should be allowed to remain with the mother so that she can be properly looked after. It's also not desirable that 2 children are, in this case, there is no 2 children. But if a female child has to stay with the mother, it will be the interest of both children and that both stay with the mother. So therefore, none of the case that the other side or the cases that we have relied upon pertains to a 10-year-old girl child who is on the verge of attaining puberty. So on the facts and circumstances of the case, I would request this honorable court continue to exercise the discretion which has been exercised earlier.
That's it.
Yes.
And the condition is that you will not, one of the conditions which we may contemplate is, and you are agreeing to this, that you will not expose your girl, your daughter, to the company of that third person, whatever your friend, whatever.
Yes. We are even willing to file an undertaking.
Oh.
To that extent, which we have done it in the way of our academic.
Knowledge.
We have stated.
So, Mr. You put flags, where are the submissions and affidavits which they are referring to? This affidavit is there.
Yes.
Where is there? You put a flag. Yes. What? We don't know. No, not reserving, Mr. So it will be delivered. Oh, we will do it. Whatever you have to. Put the flag separately. Ah, yes. Yes. Ah, absolutely correct. Ah, yeah, of course.
He has not, not seen Sanjeev Marathe since 16. For black man, it was a simple reason.
I don't go into this. We are not recording a finding on that. What is the relation, whether he is a friend or partner?
Still in contact. For $100, she
No, but-
gets money from him.
No, but he is in Canada, right? That person.
My instructions is here. He is making the. That's what all this is that you hesitate there. When he has initiated, if he says whatever I said no, whatever I produce is false, you can go there. This is not India is not put on the jurisdiction to look at the message of the same. You have to go there. He has initiated. You have to get the.
No. Please understand, Mr. Mahesh. One thing we would like to say, and it's not that we are giving the custody, and we have to yet to just a minute. But please understand, she has given an undertaking before this court in the form of an affidavit. If it is found to be false, you know what are the consequences. Counsel also appreciates. Contempt.
Two documents. I prove one. Right out. Just 199. Page 199.
No. What is how? Really?
He is not in touch. Now I want to show expose.
Please.
Page 201.
201.
Writes renewal of visa.
You told us. You told us that she had sought assistance from that person.
€100. Sorry, $100.
Z1.
Yes, sir. 201. Z1. Sanjeev Suresh Marathe. She's in touch. Card holder. I can card holder probably she is holding. I can make also counter negation, which I don't feel like.
No, what is it? This thing?
And next page, my lord.
He'll ask you to explain just me. What is it? Let us understand.
Previous page, 199.
199.
This is a letter for the renewal of the passport and visa of the child. She writes a letter.
Renewal of passport and visa.
Yes. Elegant passport renewal application, page 199.
All right.
So fee has to be.
So right, payment has been made by that person, right? All right. Why? When?
Next page.
No, when it was paid.
Online payment.
When? 3620. 3620, right? Fine.
So as
all right, fine.
And then I will can you turn to the next page 202.
202. Yes.
The application file you wrote in Honorable Family Court. You say what is the Honorable Court is to permit authorize the show review passport. I continue to and here by law, she says she wants to go back to Canada. 6 months. 605. The right to have passport and travel parties. In fact, another diagnosis for you. The response meeting is idea object is not. What she is trying to say is that passport she requires to take the child there. And now I know last week when he met the child is say through WhatsApp and Telegram. Communications is making the child to talk to this gentleman.
No. This is you are telling us how it's off the record. Please, I mean, what can we do? If it's not on record, we can't give a finding, right?
No, I'm not on that since he said.
That's why we suggested. That's why we suggested that you should. I mean, Your client is here. We were told he's going to traveling to Canada on 5th January. Today is 7th. Today is what? 1st March. He is still here. That only supports the contention that you are unemployed. You told us, right? December that he is traveling to Canada in January, 11 January. Please decide this case. We are in the month of March. He is still here. Whatever.
Only my lord is that child has undergone when she was take over there. Their issues with this gentleman called as Marathi. Therefore, my lord, the Honorable Courts of Canada said this person should not be near the child. He's not toxic. He's not toxic, my lord, for the government. That's the only reason he is here. Because practically, given the life of a child, he is not enjoying with any fellow man. Can you see that? He is here only dedicated to the child. Nothing more he has. And my Indian friends, when we moved to this argument, he said that the Articles of Canada was passed after they came to, before they came to India. That is absolutely false. Due respect to my Indian friend, it's false.
No. He said that before order was passed in the writ petition in the earlier round of litigation. So that means that's what he said.
No. Canadian courts,
No. He said that when writ petition order was passed in earlier 2019, right? Before that, the orders in Canada. We know that the orders passed by the Canada are in your favor, right? And why? What is the material that this respondent's friend is here in India? What basis you are saying? He has said that he is in Canada. She intends to reside in India.
I do not want to disclose.
No.
There are records. The records. He has done his homework. And that is homework. And he has described two families. And again, the child who was supposed to be a child and a right to the parents. She has destroyed. And he's trying to make allegations on harassment.
No, Mr. All this is beyond the scope of this proceeding. Please understand. And our problem is that we have to hear, because he will say that its opportunity is not being given to me. That's our problem. We are not going to say what we are required to decide. What is the welfare, where the welfare of the child lies, whether if he's with you in Canada, whether she'll be better off or she will be in this thing. The only concern we have frankly told that is that person, your wife's friend, is the only concern for us in this situation. But we can't place her in any other place. She has to be either with you or with mother. What to do? That's all. Nothing beyond that. And he is giving an undertaking. Please, that she will not be in touch. He is not here. This all will be recorded. And if it is found to be false, she knows. He knows that what is the consequence. Yes.
Because a lady who has destroyed a family.
All right. You tell us. No. Hey, Mister, please don't blame your wife. That's why we said that you get away with. One should live in. One should live in peace, Mr. Mahesh. That's why we told your client that they should withdraw 498A, 13B. All this we wanted for your client because he's going to Canada. Any other person in his place would like to be in peace, and instead of staying here and litigating. But you are not agreeing. We are not passing any order. We are deciding by. So if you would have agreed, these proceedings, at least 2 proceedings would have come to an end by now. What to do? You still want to, I don't understand. You still want to cling on to a dead marriage. What is it? Now it's over. This is the last day of this case in the High Court. We gave you enough opportunity. We can't decide, perhaps. That's it.
And so far as the This concern, it's very clearly mentioned by this offer. Only for that moment, you have to wait on the syndicate of members. It's only for that moment, till the disposal of the. And well, only one sentence I would like to read from the order passed by this honorable individual. Right. Individual 21, 20.
Memo. It's without jurisdiction, right?
After going through all the very same previous
Yes, we have got it. Cost of 50,000.
Order is this a pass by this honorable.
We have got it. 30 internal page 30. What? 1 minute. Page 30. Internal para message has to go. 29. In view of the above. Fine. Fine.
As not come to the court with 3 nights. She has suppressed the material fact of the case as well as the pendency of the thereby gets wasted usual time, public time, not only in the front, but also this work. The conduct of public is nothing but adding weight on the court, which cannot be encouraged. As such, in the fifth case, one was going to ensure that the party does not whatever arbitration is not very good is going to end. And my instruction is that this person is in. And the time makes it to talk to and the child was like he was not a relative, no. He was not a what actual father in the child. He cannot say no, because was not there. It's not always present to know what is transferring there.
All. That's all. Thank you. 20th December
2021.
Oh, where is which para?
Para 11.
1 minute. This states like counter affidavit on behalf of respondent number 4. This is the problem. Now you understand. Where we don't have. Yes. Where is it? No affidavit. Which affidavit? December 21st, right? Then you have filed another affidavit on 21st.
Both the parties were directed.
Please find out this. 4.
Given an undertaking, I have no intention to go back, and I think that this is.
No, but he is in, all right, but he is in Canada. Where do you say? You have not said. You have not said so in para 11. Correct. Hey, yes, we wait. Yes. Don't. He's saying to file an affidavit that he is in Canada. You know, right? Where is he? Canada. And you will not, and where is the undertaking that you will not? No, that undertaking, number one, he's in Canada. One minute. No, number one, he's in Canada. And secondly, you will not expose the child to any interaction with that person. These two undertakings on affidavit. And please tell your clients that, I mean, the consequences, especially of what happens. And you know, this court is very severe. Please, we will not hesitate for a moment if there is a complaint with regard to violation of the affidavit. Fine. You file it today. That's it. Thank you.
In the next para of the Act 12, I stated with regard to the income. I stated that I have an income to the tune of 8 lakhs.
You said, you told us 10 lakhs. It's 8 lakhs.
Sorry,
Fine.
She has to go to the back.
I just a minute. All right. Yes.
So, some
Fine. All right.
Petitioner has not contributed anything towards the child. Did not come for visitor also.
No.
It's out of vengeance that.
No. Mister, you should have sought financial assistance. He is under a legal obligation to maintain his daughter and to incur all expenses. You do what? His ego is hurt that instead of for his daughter, you are seeking assistance of somebody else. That's the problem. He is under an obligation to do so.
After the suggestion, we have withdrawn the 498 proceedings have been passed. And the 13B petition that I sent across the law clearly said that issue of custody will be decided by the court since it's already
All right.
But they do not want to grant the divorce. It's only with the view to harass.
No. No, he said no, he is ready. Why?
No, prior to the custody of you.
No. All right, we see, Mister. We tried our best to do, and I think we think. Fine. No, it's all right. All right, fine. Whatever we have to decide the question of this thing, please file an affidavit to date itself. It we should reach, and otherwise we will deliver the judgment. So please file the affidavit to date itself. Just now hand it over to the court officer after supplying a copy to them. Right?
Yes.
Two things, Mr. Mahesh, she will state that this person is in Canada, resident of Canada. Secondly, she will not expose the child to that person. That's all. No, we don't know.
Because this court has already held that she doesn't respect the courts. She's very.
All right.
False to the finding of
All right. Thank you. Thank you. See, we don't want ideally, but what we can't send her anywhere. But they don't know what they have done there in Canada. He is an engineer. Nobody is there to look after. No female supporters. Yes, this is something. The teaching. No, it is from another one. I think grandparent is part of the course. And the rest is the parent of his girl. All because he Okay. Yes, Mr. Naik.
I appear for the respondent number 5 in this matter.
Respond number 5.
Please.
I appear for the second, for the first and third respondent, Your Lordships.
Yes, Mr. Naik. So briefly tell us what is the case. Yes. Yes. Please. Please.
Your Lordships, I'm sorry for the interruption. May I request Learned Senior Counsel to use the mic, please?
Yes.
Grateful.
Hey, madam, you should be here in the court, right? When senior counsel can be here in person, when senior counsel can be here in person to address. You are a young person, you should also be here in the court. What?
Certainly, Your Lordships. I was actually present on the last occasion.
Fine.
I'll
Okay.
make grateful.
Yes.
But for the purpose of recapturing the factual position, it was necessary to be almost
Yes. Yes.
There is an overseas section of India who studied the 10+2 schooling and diploma international reference diploma equivalent to intermediate science examination, year board examination at IIM. Greenwood High. The course of study of UP Board of Cambridge University. The international education in Cambridge University. By permit study of elections of biology, physics, and chemistry apart from mathematics and CSE up to 10th standard. After provided 2 science subjects as individual credit study, along with mathematics and English for IG diploma, that is 11th and 12th standard. That is instructed and sufficient
ನಾನು ಅವರ ಮಗ ಹೇಳಿದ್ರು ನನಗೆ ಅವ್ರನ್ನ
Yes.
Including in India, but notification of association of Indian universities. Not my certificates to use which are even from the beginning. I have also finished my graduate certificate of IT4. Where is most of studied biology and chemistry. In terms of university course offered for me, coming to the next stage, what I completed my board education and had the diploma, I took my study under the National Institute of Open Studies. Institution under the Ministry of Education Beyond to meet the requirements of NCI regulations of biology, physics, and chemistry. Because of education under the NIOS, that is National Institute of Open Studies, under brochure, which is provided for self-education. There is no regular classes under the scheme of their study. Institution affiliated to that on my own, because education is imparted by several modes appreciated by the NIOS, TV, other interactive sessions, practical examinations, all that is conducted. Those are things which are set out in my journal. To meet the information bulletin issued by the National Testing Agency, nominated by the Government of India to conduct meet, which is the NCC, the part of Government of India, Directorate of Health Science, which councils for existence to All India program, during the university in United. At page 47, page 15. Examination for the Indian School Certificate examination equivalent to 10+2. I got senior technical exam after 12 years study. The last 2 years of such study which will include practical tests in these subjects and mathematics and any other elective subject with English at a level not less than 4 courses for English classes prescribed by the Institute after the introduction of structure of Besides, it would also come relevant to the topic of deciding the case. Candidates who are asked any question from open school or are private candidates will not be eligible to appear for the national eligibility for entrance test Furthermore, the study of biology, biotechnology as a additional subject at 10 plus level also cannot be found. Just talking here for a moment. These conditions must be put under control. As has been explained what by aspect note, have been stuck down work by the course of David and other four. Holding them as ultraviolently the room meeting found in the authority. But the first aspect itself points out, candidates who have passed 10 plus 2 level with biology as an additional subject will also be eligible for immediate entrance examination as per order dated 12. If the institute has to consider an examination of an Indian university or of a foreign university to be equivalent to 12 class under 10 intermediate standard examination, the candidates will have to produce a certificate from the concerned Indian university, Association of Indian Universities, to the effect that the examination passed by him is considered to be equivalent to 12 class under 10 plus 2 intermediate science examination. Second aspect four, the browser in italics have been the subject matter study regulations disqualifying, recognize working for both candidates and the candidates study biology, biotechnology as a subject has been struck down. The medical council of India has especially to go to the fields in the honorable candidates in the need for qualified examinations. Open for the state of private candidates, state boards, for the biology as an existing subject. Can be allowed, but subject to the outcome of the session of the meeting. Federal Universal or any examination which is greater than last 4 years of it's the record is found to be equivalent to the intermediate class examination taking physics, chemistry, and biology, including practical in each of the the first one is provided also that to be eligible for NEET 2021, the candidate must have passed in physics, chemistry, and biology individually and must have obtained a minimum of 50% marks taken together in physics, chemistry, and biology at the qualifying examination as next to the definition of evidence in DCI. In addition, there was a rank in the middle case of NEET. I have satisfied each one of these requirements. It's also free provided further that the students who are received education abroad and wish to seek admission into medical colleges in India must have passed in physics, chemistry, and biology and needed 50% marks in class 12 and were equivalent to determined by the institute of the talking here in the not study. It is two classes IT board curriculum, which is from the Switzerland. Because the note word is the third note here and that note is relevant. You are studying from international, foreign or international, must have traditional. So ensure that the qualifying examination passed by them are in scope and standard as explained in both sessions. As explained in both sessions was the game that I could produce an equivalency certificate from the University, the Association of Universities. The last one is any interpretation regarding the requirement of biological science as one of the subjects of the qualifying examination of being will be subject to regulation from one of the graduate medical institution as amended up to 2018 and the judgment dated 16th February 2022 in civil appeal 390 in the matter of Colombian such the brochure notifications here, which are put across by the examination secretary. Testing agent, also the application. But in the which here in the national examination and having qualified exceptionally high percentage of marks. Which 5 to 916 percentile on an all India examination and being medicated notes and exactly to instrument village. Also used by the LCC, which is part of the National Medical Council. It works like something like medical doctor given me a seat in the university, that is the medical university at Nigeria. Committing to lock my choice that change the side. For instructions of the university, I gave them things and get myself to the one, whether the documents which are placed are eligible aspect of the research. And under what grade has been the web page also disclose my qualification of having completed the requisite qualification. Because I had studied from two authorities, which I think I have to physics subject. Therefore, since there is only one column in the web page, they talk about verification. In response to this news, by the influence order, the connected in case management, they nearly set out the law, the provision. This means in the light of this problem, I'm eligible. Without reference to the advertising, the imaging force and all that has not been made. They merely extract the regulation of the NCI, which has been struck down by the Delhi High Court. And then in the light of this, I'm eligible. It is in the light of this, That means this, which has been unfortunately, the issues that are arising for consent. But at stage 2, given the age of the because these will use those, this is not a 879. Page 47 always use those 2 and 7. This is also at page 51. You are pointed out that cryptocurrency requirement and that more that it should be equivalent and freedom record the equivalent and to set out in my journal. That's not going to find words as page 36 of my
Yes.
Point of time in 2012, the employee for 2018, when all the disputes started, there is a notification issued by the NIOS, which makes a reference to series of cases which makes a reference to the process which have been set up in the insured industry. This is on page 25 and it's 52. The set up the same process if you want to Here and taken the examination. And there is no dispute about both the authorities having been certified as equivalent by the it is also restricted to 3 universities. State and what are the 3 universities and in as I pointed out, the justice have not yet been discussed by the highest court. Therefore, having committed me to having allowed me to select the instrument and at this point of time, they can't put the same issues they put for us to say that I'm not eligible and directly the university, which is resulting in both have gone into the details of how they do have examination as well as by and have made a declaration that they are equal. And most of the candidates who have done these kinds of study. Declared to be in violation of the mandate of the province under section 33 to provide for regulation. It points out that there is no application of this. How regulation is to be made, and therefore, the regulations have been declared as binding. For that limited purpose of showing that they have been declared as informed.
Which Anshul Agarwal? Which decision? Anshul Agarwal. Ah. Yes, Gangwal. Yes.
The income regulations regard how candidates who have passed 10 plus 2 years with biology, biotechnology as an additional subject, whether simultaneously or subsequently at 10 plus 2 years. The regulations for families by physicians, the first was in 1979. Within the course of the hearing, the ACS got further amended to include clarification that the include regulations does not apply to students who have studied biology, biotechnology as an additional subject simultaneously with other subjects as they as additional subject subsequent to passing of 10 plus 2 without these subjects. The NCO has a verification report modified an existing faculty without any formal amendment. The petitioner complained that this has resulted in creating an arbitrary process which resulted in category like the study biology and the does not constrain whether the include regulations in respect of petitioners and individuals persons who have not allowed to the register that there is no rationale in subject in mineral things and that about biology medical subject that they have to make the only subsequently completing their substance. Because that before everything candidates to biology anything has not carried out any regarding the study of biology without any application. The study of biology and biotechnology is not permitted simultaneously with mathematics at 10 plus 2 years. And one has to study biology, biotechnology only after completing 10 plus 2 with mathematics. It's permissible to study both mathematics and biology simultaneously at regular class level. The students attend regular classes in examination. The student can opt either biology or mathematics. And they have main subject. If the candidate opted for mathematics as his main subject, he has the option either to pass biology as additional subject in the same year or as the main subject in the next year after passing 10 plus 2. It was submitted that the include India regulation such a situation where the candidate studying biology for 2 years with failed by practical classes. It is only different from other permitted candidates that they pass biology examination. Therefore, the include regulations confer undue benefits to students from both solid simultaneous studies at 10 plus 2 years. And the regulations board who do not permit the subsequent to passing the 10 plus 2 without biology, I think the candidates were is just patently misleading. It is argued that the initial qualification is not the data. In my case, I am one step better than those cases because I have studied biology as a core subject in all these. There is no dispute about it in all. I've taken physics because the IB board does not permit physics is a core subject for engineering. Though the NCR regulation says I should have studied only 3 at the board level. To address that issue, this has been facilitated by NIOL, which permits independent study and taking this examination with passing work, which is a course being conducted by the government of India itself. Other open universities. Reading further down, the last 2 lines in the collector, that is in recent days, that if the practice is practiced in manner of doing a thing, it has to be done in the same manner. But this preceded by a discussion pointing out that when the change of regulation, there was no discussion, there was no application. The authority to the teacher consulted since against it. Despite that, though the minister sought further input, it was proceeded with, and therefore, since it is not applicable, Section 33 requires it to be done in a particular manner. It categorizes this action as the violation of Section 33 and therefore badness. Paragraph 10. Once or two relationality of notes are explained these, which say one of notes the last 5 lines in which case the guidance of the Furthermore, the council said that the previous judgment in Mr. Garba, passage from which ruling was heavily relied during the hearing, has now concluded that even those who do not undertake additional classroom and rather attend very few classes in the entire academic year, that is, those opting for NIOL, have been permitted to appear. As being the case, the NCI claims that continuous classroom education and appearing in simultaneous examinations in all subjects, including additional subjects, it is useful to notice that the division bench is examining the matters of the same instrument in answer, and there is that to the extent it is excluded from participation, those selecting from open schools this will be examining the reports of the NCI. This is when as well as the system making process of examining the institution. The case is also defined. I am not speaking that on the attendance in these classes is compulsory. The exams should also conducted as a daily uniform. So, exams following national practice in 2005. So, evaluation. And I also then the curriculum has exams were conducted for both level schools. Sometimes in the regulation to make it clear, the regulation of the being of the group, that as the group categories those appearing in the state education board do not have to undergo and then appear in that subject. To be able to do this means that the influence that all subjects I was Third class covers those who appear in the examination operation. The other half is the gap is only no consistent pattern in the artificially understanding. Any other examination which is scope and standard Study of language only in 9th standard could be there to be equal. So relevant to the scheme of examination is given. And since it can be shown as equivalent because admittedly they have not studied for lessons and skills. That's the reason it was adopted in the semester. Therefore, the difference is where if you have studied in 9th and 10th and not studied in 11th and 12th, you can't be equated. Despite the certificate of study, the authority finds that that course will be equivalent. But since we have not studied in 11th and 12th, we don't really need that study. That's what we need to do. This is something important to say. Except the difference of the having like entrance examination, if you ask more, having committed you, including you, at this point of time, that I was really totally very regular. There are two observations.
ಅವರೆಲ್ಲ ಒಂದು ಕರೆಕ್ಟ್ ಕೆಲಸ Mr. Sandra.
Yes. You are appearing for Mr. Take your own time. Take your own time. Yes. Yes. One minute. Give us 1 minute. ask her to write the order sheet by hand. So we'll sign it just now. Mr. Naik, Senior Counsel with Mr. Abhishek Mali Patil concluded his submissions. However, Mr. Mr. Learned Counsel for respondent number 4. Next line. Mr. N.K. Learned Counsel for respondent number 4 commenced his submissions. However, on account of paucity of our paucity of time, the same could not be concluded. List whatever on 2nd March 2022 for further hearing. You write this. Yes. No, you continue. I mean, she will write. For 2:30. Further hearing may come up. We don't know where, how many cases are listed. Oh. Yes.
including India earlier. Come here now. It's here. N1 to N, N to N1, basically. They are aware. That will not be inadequate as far as we are concerned. They will use one point of time. So equivalent. I agree that this is the first request. This is because that comes to your interest what is true and what is intermediate. This people that much there. The mistake of that aspect is what is true. But you equate it plus two, they requirements for the purpose of medicine as a professional course mandate, you would have to do these three subjects in that board. If that board is not located that, it is not the board mandate.
Continue day after at 2:30.
That is.
My lord, with kind permission, my lord. Serial number 65, my lord.
We can't take it up today now. Yes,
my lord. Week after
and
next, my lord.
You can make an prayer for adjournment day after also. Huh?
My
There's
lord,
no urgency. We don't know who is appearing for the other side. Let it be. Make a mention day after. What is this? We don't know. He may oppose the prayer also. We really don't know. We don't have any matter.
Please, my lord.
Huh? Repeat. Day after.
ನಮ್ಗೆ ಡೈಲಾಗ್ ಹೊಡೆದು ಹೋಗುತ್ತಾ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್